Personal difficult. That's why Mr. A.M. Bora had to leave, Lordship. He has not come to the court. So I did inform the respondent. We are the respondent. I did inform the appellant side yesterday evening and also the PP office, Lordship. Item number
Last night,
14.
Mr. Day told me that there will be an adjournment.
Item
Day
number
for the
14.
appellant.
We are for the respondent, Lordship.
A request made on behalf of AM Bora, Learned Council, for the respondent number. For the,
Respondent number 2. It is appeal against acquittal
okay, respond number 2. Please the matter
after 3 weeks, Lordship.
3 weeks.
Highly obliged.
May I please, Your Lordship, that write-up I have given of that Balia Mura's case. Even Mr. Azad.
I have also submitted a written copy.
It's not very short. It's 4 pages because I had quoted Ratan Singh's few paragraphs. So it has become little big. Otherwise,
Doesn't matter.
it's short. Lordship.
Right.
Item number, Lordship, there is 3 items in the supplementary list. I have some personal difficulty. If it can be taken up from day after tomorrow. Hemaji bomb blast case. I have otherwise looked into. It can be taken up day-to-day hearing would have been better.
Who's appearing?
His,
I'm a paid appellant.
You are Mr.
DK Bhattacharya.
Okay, heard Mr. DK Bhattacharya, Learned Council,
I'm not
in
sure.
criminal application 05 of 2019.
My lord,
My prayer is it can be continued from Wednesday, but I think
if it
he
can
has-
be taken up on 5th, that is next Monday, day-to-day hearing, if possible.
and there will be no more adjourn from my side. No, never.
Also heard MSS Jahan, Learned Council, Learned additional PPS. List the matter for hearing on 5th.
5th June.
That.
Obliged.
One of daily motion.
This matter we can dispose it. Huh?
My lord, item 1, can it be for time being, my lord, in this matter, Miss Rita Devi is appearing. My lord, she is in other court, my lord, can it be taken up after some time? Yes, my lord. Obliged.
To admission.
Lordship, item 2, I'm appearing on behalf of the accused in my capacity as a legal aid counsel, Your Lordship. And the present appeal has been preferred by the accused against the judgment and order of the learned special judge Gwalpa, Your Lordship, convicting the appellant accused to undergo rigorous imprisonment of 20 years under
When was
section
the
4.
judgment passed?
Lordship, on 4th of February 23, Your Lordship.
Foxo matter.
Heard MS.
S. Sharma Hazarika, Your Lordship.
Sharma Hazarika. Admit all points, yes. MSS Jahan, Learned additional PP. Appears on behalf of
Respond number 1. Respond number 1. So
respond, sole respondent? On behalf of the sole respondent. Stop. This is the matter. After 4 weeks.
Obliged.
3.
My lord, it is a appeal conviction under section 302, life imprisonment. Notice may be issued to the informant.
Deaconate.
Yes.
Heard Mr. Deaconate, Learned Council for the appeal. Admit call for yes. MSS Jahan, Learned additional PP.
Respondent number 1.
Appears on behalf of the respondent number 1. Apple takes steps for service of notice on report number 2 by registered post AD within 1 week.
Yeah.
Completed. List the matter after 6 weeks.
Publish.
4, order
My pleasure, Lordships. I'm the new council in this case, Lordship. Earlier council has been changed. So I'd like to, Lordship, I want to file on additional affidavit, some things to be added, Lordship.
Your good
I'm the
name-
new council.
Your good name, please.
Mr. G Das, Lordship. Want to find additional affidavit in this case, Lordship.
What edition? are you doing?
So some submissions are yet to be, has been not annexed in this appeal memo, Lordship, by the earlier council, Lordship. So, Lordship, these are to be added, these are to be some points are left away by the earlier council. So I'm the new council. So I want to file one additional affidavit, Lordship.
Dr. Mr. G Das, the council for the appeal, is allowed to file an additional affidavit. Fill it out
2 weeks, 3 weeks time,
within a
3
period
weeks.
of 2 weeks.
2 weeks, Lordship.
List the matter after 3 weeks.
PKJ.
Authorize Mr. BKJ and then council for the response.
Most of it.
5,
Lordship, so far I am concerned here, Lordship. I filed an affidavit in opposition. That has not come. It was filed, your Lordship. As per, it was filed on, Lordship, 7, Lordship, 20, March 23, it was filed.
Don't say also, but cancel that. Mr. BKJ and the council for the response. Submit that he has filed an affidavit in opposition on the chief individual. The same is not on record. Register to verify it is not on record. It's formed in order.
When we did it,
Yes,
when we did it.
4 weeks.
5,
Made clear also.
Lordship, my senior
Yeah,
is
Lordship, I have-
asking me to pass over for time being.
Who's your senior?
SCKL.
Kindly. Yeah, Lordship, I have filed one interlocutory application seeking bail on the ground that he has completed more than 50% of the sentence, Lordship. And therefore, in terms of section 436A of CRPC, I am entitled to bail, Lordship.
Let us wait for King.
Lordship.
take
Made please, your Lordships. Actually, this is a second bail application. Actually, the earlier bail application was taken up by Justice Jothangthuma and Justice Nandi. But issue is that, my lord, the applicant here, he's not keeping well. His pressure is shooting like it's more than 200 plus, his blood pressure. In fact, this bail application is only because of his health conditions. He's lodged in Borigaon jail and jail
You
infrastructure.
don't have a doctor there.
No, in
My
fact,
lord?
on the last occasion, I got a medical report.
Medical report came. In fact, my lord, I have given another medical report. If your lordship comes to page 80 of my application.
Where's the medical report?
Application IA number 421.
There's no medical report. Is there a medical report?
IA 421, that's page 80. Your lordship comes on the top right hand side, his blood pressure is mentioned 210 by 120. My lord, then later on page 82 and 84. He's complaining of severe headache and he has been told to do CT scan for brain. My lord, any blood pressure above 180 leads to hypertensive crisis, means he's on the verge of having a mental stroke. But this person is above 210. Only for medical reasons I'm asking, and he's an 85-year-old person.
On 23rd February, I think I got a report where it is said he is not that ill. And on that basis,
Where's
that
that
was,
medical report?
that was.
That was in an
submitted on
earlier petition, my lord. If your lordship comes to page 70,
23rd February.
If your lordship comes to page 78, if your lordship comes to page 78,
78 of this application.
paragraph 13. It was stated that applicant was found to having blood pressure, vertigo, migrainous headache. His blood pressure was 190 by 100, even at that point of time. That medical report suggested 190 by 100. And that medical report says that he's in a hypertensive crisis situation. Now it has again gone more than that. And the jail authorities have actually asked that you better take him out.
I can get a report, a fresh report again. As far as the last report, his condition was not serious as reflected in paragraph 13. He has vertigo, blood pressure, and migraine headache. His blood pressure was so and so on the date of examination, and he has also joint pain, which are not serious in nature.
Joint pain is not serious, but pressure. In fact, this medical report at page 80 advised sleep that is a 4/4/2023. After that, after a dismissal of the earlier bail application, it says blood pressure 210 by 120. He has a history of high blood pressure.
Let me get a fresh medical report from the jail authority.
Yes. But Mr. Aditya Bhattacharya in the I. Senate also would have to. By this application. Applicant is praying for bail. On the ground that the applicant is having high blood pressure. Accompanied with
Other hypertension problems,
other
vertigo.
And Mrs. Jahan, the additional shall produce an up-to-date medical report of the applicant by the next week. List down. After,
Anyway, Friday next week, I'll call the
And
superintendent.
as early as possible.
this matter on.
Wednesday night.
Second.
2nd of June, Lordship.
Lord.
Friday.
Obliged.
Seven.
May I please, lordship, as per the order dated 22/5/2023.
Why is this like this? What? But criminal matter? Okay. Yes.
May I please, as per the last order, parties are directed to appear and accordingly they are appeared.
Yes, where the parties?
Yes, appellant.
Alimony of 1 crore.
Yes, lordship.
Where's the judgment?
Lordship, page 10 judgment. Order is the page 10. Page 10 of IA.
With whom is the daughter? Who are the two daughters?
Dr. Andekam.
The two daughters are with you,
Pardon,
the daughters,
daughters are with the mother.
both the.
Both
the
the
daughters. Are you paying anything now?
Lordship, as per the order of the family court, we are paying 20,000 per month regularly.
20,000 will not be sufficient.
Admittedly. Lordship, if possible, matter may be sent to for mediation, if possible.
To?
If possible, Lordship, matter may be sent for mediation, then we can discuss the matter. Because Lordship, 1 crore is very high, and it is impossible for us.
You have any other source of income?
No.
No, sir. It's 20,000 sufficient for you.
No.
Lordship, so want to say something, but in Assamese you'd like to say, can the,
Assamese will be a big problem.
okay. Hindi, will it be okay?
Can we try Hindi? Yeah, we can try Hindi.
Your Honor, मेरा 2 डॉटर ही मेरे साथ ही रहते हैं। आज से 14 years से मैंने ही उन दोनों को बड़ा किया पूरा 20,000 ये मुझे पे करते हैं, लेकिन 20,000 कुछ भी नहीं होता है मेरे लिए। तो अभी फैमिली कोर्ट से जो ऑर्डर मुझे मिला है 1 करोड़, वो सिर्फ मेरे लिए नहीं, मुझे दोनों डॉटर का शादी, जो भी फर्दर उन लोगों का एजुकेशन सब मुझे ही करना पड़ेगा, क्योंकि ये कुछ भी नहीं कर रहे। तो मैं चाहती हूँ कि मेरा जो ऑर्डर फैमिली कोर्ट ने दिया है वही मुझे मिले। मेरे लिए ये कम ही है, क्योंकि आजकल 1 करोड़ 2 बेटी को शादी देना, एजुकेशन मैंने ही पूरा कंप्लीट किया उन दोनों का, 14 years से मेरे साथ है। वही मैं प्रे करती हूँ कि मेरा जो मिलना चाहिए मुझे आप लोग वो दें। थैंक यू।
Lordship, we are ready to bear all expenses of the daughters. And accordingly, whenever she call for the required.
When you are paying only 20,000, how can she take care of her daughter?
Lordship, yesterday evening also, her 2 daughters meet him and discuss the matter. So, if not possible, kindly send for mediation, if possible. Because Lordship, 1 crore is too high.
You make some deposit.
Lord,
You make some, how much can you pay? At this stage.
Lordship, if 1 week, 1 week time may be allowed.
You pay the amount?
Yes, sir. He
What,
will
1 crore?
no,
How much?
he needs some time to
What's
decide.
what's the time? Why do you need time?
Lordship, I need a little bit of time to think over the matter because the amount is too high for me.
That's fine, that amount is too high for me, but for the time being, she needs to take care of her children also. Of your daughters.
But I would like to say that if you kindly give me some time, little bit of time.
Lordship, there are,
Orders of 2021. Isn't it?
right,
You deposited 10 lakhs for the time being.
But that too is too high for me, your
Oh,
lordship.
You have a
Lordship.
good booming business.
No, I don't have that. It's too high for me. Okay.
Lordship, on record, he has 51 shops in the Fancy Bazaar on record, Lordship, but there are probably around 83 shops that I tried to bring on record through the witnesses, 83 shops. Even if on an average, if I count, then if the rent of the shops will be 10,000, he earns 8.3 lakhs per month, Lordship. It's in a Fancy Bazaar, and the business is called Akram Business. There's the entire building, Lordship. So under that circumstances, Lordship, the 1 crore is very little, Lordship. He has income around around 1 crore income in a year. And these two daughters, then it also need to get married, Lordship, for the expenses and all. And my prayer would be before this, before Lordship, that at least 50% of the amount, if it is paid, it may be admitted for hearing, Lordship.
Yeah, that's what we are thinking.
Lordship, Akram business is definitely, there is a Akram business, but all the shops are in the name of his late mother. And there is a probate case by his
So,
sister. So Lordship,
Probate case is not on record, Lordship, and sister is what he's saying is the adopted sister. No document was submitted regarding the adopted sister.
You deposit 50 lakhs and then we'll admit it for hearing.
Lordship, kindly fix this matter for next week.
Why?
We have to discuss with our senior and that.
Meantime, what happens to the 2 children?
Lordship, 1 week, kindly. Next week, I'm
No,
ready. Lordship, kindly for next week.
We'll take it up on Wednesday, day after tomorrow,
Friday, Lordship, kindly.
day after tomorrow. You come prepared with the amount that you want to deposit.
Friday, Lordship, kindly.
Wednesday is okay.
Come on Wednesday. What's there to think about? You know better. Everything is within your knowledge. What's there to think about? In fact, we can pass an order now also. Have you passed the order?
Wednesday.
Okay. Both the parties are present in court and also represented by the respective councils. So, on the request of Mr.
Yes, Honor.
A. Shawal and the counsel for the appellant. This is the matter on 31st May 2022. On that day, you come, will pass appropriate orders.
Any evidence?
The parties are also that it's in report on the next week.
Lordship, parties will also be present.
Yes.
Obliged, Lord.
Any evidence?
Item 8 and 9 hearing.
Lordship, today the matter has been fixed for.
Ma'am,
submission
for written
of an
argument,
argument. We
ma'am.
have prepared our argument, submission.
But Mr. Ayatollah and the counsel to the appellant in criminal appeal number 287 of 2019. as well as Mr. A. Diwari, learned counsel, amicus curiae, representing the appellant in criminal appellant within bracket J, number 15 of 2022. Also heard amicus grant and additional class. Just one reason.
Five,
Lordship, in the shift of my learned is file and miscellaneous application, praying for bill. Lordship, I want, it's time to file my objection to that.
Dear Lordship, I have filed a bail on the ground that I have completed 50% of the sentence, Lordship, and that is on record. For whether that objection is required or not, Lordship,
Yes,
may
Lordship,
kindly
because
consider.
Lordship, the case was earlier fixed for hearing. On the instance of the my learned friend, they took a plea of juvenile, Lordship. And
Okay,
Yes.
Since he wants to file, let's.
1 week time may be
but,
granted.
I'm
Lord.
giving a short period, Mr.
7 days, Lord,
1 week time.
Lordship.
And date may be fixed. Lord.
Heard Mr. Ahmed, learned counsel for the applicant, issue notice. Any other parties involved?
No, Lord,
No, Lordship.
Mr. Ezekiel, learned,
standing counsel for NCB, Lord.
learned standing counsel,
NCB, narcotic control.
NCB. Press for which time to file objections, press allowed.
Much.
It's the matter of 1 week.
Lordship, may I pay for a date, Lordship?
This the matter on today's what,
29.
29th. 7 June.
Oblige.
Hearing,
Call up item 1.
item 1, motion.
Yes, Devi?
Yes, Lordship, my pleasure, Lordship. Here the petitioner, the SSB is the petitioner, Lordship. The SSB is agreed by the interim order that 3/1/23 passed by the learned Guwahati bench, Lordship.
Where's that order?
Page 42.
Yes.
By this order, the petitioner has been directed to allow the respondent to join in the sector headquarter, SSB sector headquarter in Rangia.
Mm.
That's it, what happened, the respondent, who is an assistant engineer grade 1 in SSB, he was transferred from Rangia to Almora, Uttarakhand on 8/4/2022.
You file an MA.
But the MA file, it is not considered, and the matter is ready for hearing, but
So
hearing is not done.
let the tribunal consider your MA within.
Not
and
MA Lordship, it may be taken up for final disposal, because since last 1 year, it is pending after the pleadings are complete, or everything complete, and at this stage, his interim order has been passed to allow the petitioner to respondent to join in his
Okay,
Rangia.
then we'll direct that the OA be heard in.
But finally had and disposed of, Lordship. Because if it is again take the MA or everything, it will further take time, because there is a shortage of manpower. And from last 1 year, he has not gone to the Almora.
Tribunal is sitting regularly now,
Yes, Lord. It is sitting.
then we can dispose it of within 2 months.
Lordship, next date is on 12/6. On that day, it may be taken up for disposal. The action may be passed.
12/6.
12/6.
But MS R Devi, no, not CGC, isn't it?
Lordship.
For the petitioner. No one for the other side?
No, Lordship.
Stop.
Private
All right.
party.
The petitioner is represented. Who is representing you?
Lordship.
Who's the petitioner?
Petitioner is a SSB Lordship along with Union of India. Sashastra Simabal, Director General and Commandant.
Is the Sashastra Sima Bal, which is represented by the Secretary, Government of India, Ministry of Home Affairs, New Delhi. Stop. By the present writ petition, the petitioners are aggrieved with the order dated 3/1/2023 passed by the learned tribunal in
OA 109/22.
in OA 109/2022, whereby the respondent has been, whereby the petitioners are directed to allow the respondent to join the SHQ, SHQ SSP Rangia till the disposal of the said OA. Stop. But it is the case of the petitioner that when OA/109/2022 was taken up on 25/2022, the learned tribunal passed an order directing the parties to maintain status quo till the next date of hearing.
Before that, Lordship, after,
However,
yes,
prior to the passing of the status quo order on 25/2022, the petitioners herein had already relieved the respondent on in the afternoon of 25/2022 with a direction to report to the commandant within bracket AD administration SHQ, SSP Almora on transfer. Stop. Therefore, learned counsel for the petitioner submits that by the impugned order dated 31/2023 submits that if the order dated 31/2023 is therefore the learned counsel for the petitioner submits that by the order dated 3/1/2023 the respondents, the petitioners are required to allow the petitioner or respondent to join in Rangia
already allowed, Lordship.
despite the relief order being issued prior to the issuance of the OA. Stop. It is also submitted that the petitioners had filed MA number 11 of 2023 before the learned tribunal, praying for vacation of the order dated 3/1 of the interim order dated 3/1/2023. Stop. But after hearing the learned counsel for the petitioner and on consideration of the fact that the OA number 109 of 2022 is in the hearing stage and is fixed on 12/6/2023, we accordingly dispose of this writ petition without entering into the merits by directing the learned tribunal, by requesting the learned tribunal to finally hear and dispose of OA number 109/2023. On the date fixed for hearing, IE 12/6/2023. Stop. With the above observations, this writ petition is accordingly disposed of.
Obliged.
Then hearing.
May it please lordship.
Mm.
Lordship, kindly matter will be taken up after 2 weeks.
Why? Have you informed the additional PP?
Last night he said, Mr. Rupti Day, he told me,
Are they?
our day. It's a school student who was killed by a villager.
Okay. On request made on behalf of our day, learned counsel for the appellant. List the matter after
2 weeks.
2 weeks.
Highly obliged.
11.
Lordship, I have been appointed as amicus in this matter, Lordship.
Yes, please.
Yes, Lordship, I'll take your Lordship straight away to the judgment, some relevant paragraphs, Lordship, I would like to point out. Page 20, it starts from page 23. But I would like your Lordship to come to page 25, your Lordship.
Yes.
Paragraph 9, Lordship. I'll just like to point out. So now admittedly, the body of the deceased was found hanging in the backside of the house of deceased. According to the opinion of the doctor, there were bleeding injuries that resulted in severe hemorrhage. There is no evidence of any suicidal hanging because no evidence of total has been found in the postmortem examination. In these circumstances, it is held that death of Nifty Limbu was homicidal in nature and the possibility of committing suicide is ruled out. So basically, Lordship, this whole judgment is based on the postmortem report. So postmortem report, it is stated that there is no total mark. So now, Lordship, I will take your Lordship findings. Page 28, your Lordship.
Yes.
Paragraph 21, your Lordship. May I read out? The evidence reproduced above establishes that relationship between the accused and deceased was not good, and the accused used to quarrel with the deceased. The accused and the deceased did not have any children, and therefore the unfaithful night, the only other inmate of the house of the accused was deceased. So this thing, Lordship, may point out, take note of, that there's a finding that the deceased did not have any children. Then the oral evidence establishes that there was blood marks on the body of the deceased, and this fact is heavily corroborated by the medical evidence, which has revealed presence of deep cut injuries on the face of the deceased. Para 22, the learned counsel of the accused argued that if the deceased was dragged and his murder was shown to be a suicide, then her body must have scratch marks and her clothes must have mud stains. I have considered this submission, and in my opinion, such argument, even if assumed to be true, does not strike at the root of the prosecution case. For the principal fact is murder first and then showing it to be suicide. The medical evidence establishes that the death was due to severe hemorrhage and not due to suicide. unless there is anything to discard the medical opinion, the opinion stands true moriso. The present case where ocular evidence also suggests that there were blood marks in the body of the deceased. Then Lordship, paragraph 23. The present case, the fact that the accused and the deceased had no children. The deceased was last seen together along with the accused. So Lordship, last seen together concept has been brought in. So this Lordship is totally untrue. That Lordship, I'll come to that. Both of them slept together by retiring to the room at that night. So there is no evidence that the both of them slept together. I'll just come to the evidence later on, Lordship. I'm just pointing it out. Last seen together, legal parlance ordinarily refers to the last seen together in the street, at a public place, or at any place frequented by the public. But here, last seen together is much more than that. The last seen together here is sleeping together inside the bolted room. So these are all presumptions. As held in Buthraj versus State of Jammu Kashmir 2028 SCC 45, the last seen theory comes into play, where the time gap between the point of time when the accused and the deceased were last seen alive and when the deceased is found dead is so small that possibility of any person other than the accused being the author of the crime becomes impossible. The only explanation offered by the accused is that his wife committed suicide. Explanation offered by the accused falls flat in view of the evidence of homicidal death of the deceased. So Lordship, 313 question also, I'll come to that later on. This question was not asked whether they were sleep together, they were together that night, fateful night. Then Lordship, thus it is found that the following circumstances are established beyond reasonable doubt: that the accused is an alcoholic and used to quarrel with his wife, that the accused and the deceased were last seen together inside their house. There is no evidence on this, Lordship. That death took place during the night hours, that the possibility of any other person committing the offense is absolutely ruled out. There is neither any plea nor any circumstances to suggest that the injuries were self-inflicted, that the death of the deceased was homicidal in nature. The aforesaid circumstances leave no manner of doubt that none but the accused had committed murder of the deceased and hanged her body in such a manner so as to show it to be a case of suicide. The evidence on record excludes any hypothesis of innocence of the accused. Then Lordship, I'll just skip it. Skip these paragraphs. Then Lordship, the order. Order for the accused Indra Bahadur Limbu is convicted for offense under section 302 IPC, sentenced to undergo rigorous imprisonment for life with further sentence of payment of rupees 5,000 in default and suffer so and so. Now, Lordship, I'll take your Lordship to the evidence parts. Evidence, Lordship, PW1 is at page 9.
Where's the FIR?
FIR is at page 4, Lordship.
Who lodged the FIR?
FIR actually it's on the basis of an information, and FIR has been lodged by the ASI, Assistant Sub Inspector of Police. So may I read out, Lordship, FIR? The FIR dated 18/3/2019. Sir, humble submission is that on 19/12/2018, village headman of Khalasi Gaon informed me over the mobile phone that 50-year-old woman of his village, namely Nipti Limbu, wife of Indra Bahadur Limbu, committed suicide by hanging herself on a Damboru tree in the backside of her house. On the basis of Patgaon Outpost GD entry numbers 275 dated 19/12/2018, I visited the place of occurrence, examined the witnesses nearby, and seized the rope with which she hanged herself to death by preparing a seizure list in presence of the witnesses, got the inquest done by the magistrate Kokrajhar. Thereafter, dead body was sent under custody of UBC 157 Amritlal Brahma to get the post-mortem examination done by the superintendent of RNB Civil Hospital Kokrajhar. Thereafter, on the basis of information given by the village headman of Khalasi, an UD case being numbered 6/18 dated 19/12/18 was registered in Saffranguri police station, and accordingly the case was investigated. Today on 12/3/2019 in the evening, I received the post-mortem examination report from RNB Civil Hospital Kokrajhar by post and found the doctor mentioning in his report, in my opinion, the cause of death is due to severe hemorrhage and it is antemortem in nature. I therefore inform you that this is a murder case and that it cannot be a case of suicide. Hence, it is prayed to you to find out the murderer of Nipti Limbu, wife of Indra Bahadur Limbu, and arrest him as well as take necessary action against the culprit as per the provisions of law and oblige. So this has been filed by ASI Jitendra Singh. So it was on the basis of an information given by the village headman. Now, Lordship, that evidence part, Lordship. Page 9, Lordship.
Yes.
So page 9 is, my name is Srimati Himani Basumatari. So she is a neighbor. So her evidence is that I know the accused. Accused is an alcoholic and he used to quarrel with his wife every night. I only know that wife of the deceased died. I do not know anything else. So she doesn't know anything. She only got to know that like she died, nothing else. Then PW2 year Lordship at page 10. Dharme Basumatari. I know the accused. I have heard that his wife was found hanging on tree. I do not know anything else about this case.
He's also neighbor.
Yeah, it's a neighbor. These are all neighbor. Then page 11, your Lordship will find PW3. He is also neighbor. I know the accused. On the day of occurrence, I was recovering after a surgery. On the following morning, I came to know from villagers that wife of the accused was found hanging on a tree. I do not know anything else about this case. So he also doesn't know anything. Now, Lordship, this PW4 is the ASI that who has lost this FIR.
Informant.
Page 12, your Lordship. PW4, Jitendra Singh. On 19/12/2018, I received an information from the Gaonbura of Patgaon that the body of Nipti Limbu, wife of accused, is found hanging on a tree. After getting information, I went to the place of occurrence along with police team and found that the local villager have brought down the dead body. It was already taken down from the tree. I immediately informed the officer in charge of Saffranguri police station, and an unnatural death case was initially registered as UD case number so and so. The dead body was sent to post-mortem examination. The PM report revealed that the death is due to severe hemorrhage and it is antemortem in nature. Further, the inquest of the dead body was also done by Executive Magistrate. Exhibit 2 is the inquest report, which was forwarded to me by the Executive Magistrate. On the basis of the inquest and the PM examination report, it appears that death of Nipti Limbu was homicidal, and accordingly, I lodged an FIR. Exhibit 1 is the FIR. Exhibit 1.1 is my signature, and Exhibit 3 is the seizure list. And Exhibit 3.1 is my signature. And the cross-examination part, your Lordship, the next page. I went to the place of occurrence at 6:30 a.m. Lordship, may kindly note this timing. 6:30 a.m. in the morning. The Gaobura told me that the rope lying near the dead body was the rope on which the dead body was hanging. The witness present at the time informed me that the accused and his wife used to quarrel with each other, and both of them were alcoholic. So Lordship may kindly note down the next sentence. I did not see any mud on the body of the deceased. The wearing apparel of the deceased was not torn. In FIR Exhibit 1, I have not mentioned that it is a accused who committed murder. Exhibit 3, seizure list, I have not taken the signature of the Gaobura. The seizure witness in Exhibit 3, Arun Limbu, has stated in his statement under section 161C of CRPC that he's signed in the seizure list at 9:50 a.m. So this timing, Lordship, 6:50 they have arrived in the place. So seizure list was supposed to be made at 9:50. So it's, 3 hours. I'll show something else to be pointed out, noted down, Lordship, later on. So just this timing, Lordship, may kindly note. 6:30 and 9:30, 9:50. Other witnesses have also signed at 9:50 a.m. It is not a fact that Exhibit 3 was not prepared at the place of occurrence. Then Lordship, page 14, PW5. This is the doctor here, Lordship. That's the doctor who has conducted the postmortem. Dr. P.K. Dole. On 19/12/2018, I was posted as medical and health officer at RNB Civil Hospital, Kokrajhar. On that day, on police requisition, I had conducted postmortem examination of the deceased Nifty Limbu, aged about 50 years, and my observation are as follows. Lordship, may kindly note down the observation part. Cut injuries over face 2 in numbers, deep cut 3/2 size, abrasion injuries is swelling around the neck. So there was a swelling around the neck, Lordship. That has come in the postmortem report. Injuries are sufficient in the ordinary course of nature to cause death. In my opinion, the cause of death is severe hemorrhage, and it is antemotive in nature. Then the cross-examination part, Lordship, will find, I did not find any scratch mark in the body of the deceased Nifty Limbu, indicating that she has been dragged. So it is a case, prosecution case is that it is a case of killing, then hanging it on the tree. So here it comes that there is no dragging of, because body has to be dragged, body has to be taken to the tree. It's a adult lady, so it has to be taken. So here it is coming that there is no sign of any dragging. Now page 15, your Lordship, there is another witness, PW6. My name is Sri Bhimdhos Limbu, page 15, your Lordship.
Yes.
I know the accused. About 4 months back, accused came to our residence and informed me that his wife Nifty Limbu is hanging on a tree behind his residence. I went to the residence of accused and saw that Nifty Limbu is hanging on a tree, but her feet was touching on the ground. I had seen blood mark on her body. I immediately informed the in charge Patgaon police station. So Lordship, as a Lordship, I have read out that Jitendra Singh's that ASI's evidence. He did not mention about any mark on the body. So here it says that I had seen the blood mark on her body. I immediately informed so and so. Then on the cross-examination part, Lordship will find at page 16. it is not a fact that I have not stated before the police that I had seen Nifty Limbu hanging on a tree, but her feet was touching the ground. It is not a fact that I did not inform the in charge of Patgaon police outpost. I knew that Nifty Limbu was an alcoholic and she had no children. Nifty Limbu was a short-tempered lady and she used to threaten the accused that she would leave his society. Police team had returned from the place of occurrence at about 7 a.m. This time, Lordship may kindly note down, 7 a.m. And as per Jitendra Singh, the inquest report was done at the spot at 9:50. But he says that they have already left at 7. Then page 17, Your Lordship, another PW7, Sanu Subba. I know the accused. About 4 months back, accused came to our residence and informed me that his wife Nifty Limbu is hanging on a tree behind his residence. I went to the residence of the accused and saw that Nifty Limbu is hanging on a tree, but her feet was touching the ground. I had seen blood mark on her body.
This another neighbor.
Lordship, neighbor whom this accused has supposedly went to his house and told about the incident. Then Nitu Changmai, Lordship, Nitu Changmai is a police officer who has investigated the matter later on. Page 18, Your Lordship. On 18/3/2019, I was posted at Patgaon Police Outpost. On that day, I was entrusted with the investigation of this case. In the course of investigation, I visited the place of occurrence. I had recorded the statement of the witnesses. I also took steps for causing postmortem of the deceased Nifty Limbu. After getting postmortem report and having found sufficient materials against the accused Indra Bahadur Limbu, I submitted the charge sheet against the accused Indra Bahadur Limbu for offense under section 302 of IPC. Exhibit 5 is the seizure list prepared by me, by virtue of which I have seized a piece of rope, and exhibit 5.1 is my signature. Exhibit 6 is a charge sheet, and exhibit 6.1 is my signature. The cross-examination part, Your Lordship, the accused was not named in the FIR. PW4 Jitendra Singh did not state before me that he received information from the Gaonbura of Patgaon regarding the date of Nifty Limbu. The statement of PW4, Sri Jitendra Singh, was recorded at Patgaon Outpost. PW6, Sri Bhimdos Limbu, stated that he received information on 18/12/2018. PW7, Sri Sanu Subba, stated that on 19/12/2018, she came to know about the date of Nifty Limbu and went to see her body. In the seizure list, Exhibit 5, the case reference has not been mentioned. The seizure list Exhibit 5 does not mention from where ASI Jitendra Singh found the rope. It was not mentioned there. It is not a fact that seized articles white Exhibit 5 is not connected with the case, and it is a seizure in connection with some other case. It is not a fact that Nifty Limbu's death was suicidal and not homicidal. And it is not a fact that I have not investigated the case properly. Now, page 20, Your Lordship will find that examination of the accused. It's a denial, Lordship. The questions will be relevant. So page 21, Your Lordship. PW1 Himani Vasumtari has deposed that you are an alcoholic. It is not true. PW1 has also deposed that you used to quarrel with your wife. It is not true. I had a good relationship with my wife. Then Lordship, question number 5. Dr. P.K. Dole has deposed that 2 cut injuries, deep cut, and abrasion injuries were found around the neck of the deceased. It is not true that there were cut injuries on the body of my wife. Then Lordship will question 7. PW Sikh Bhims Dose Limbu deposed that he had seen the body of Nifty Limbu hanging on a tree, but her feet was touching the ground. It is true that my wife was found hanging. Then Lordship, I'll just skip this. Then the last question here, Lordship will find that question number 11. Do you want to adduce any evidence or do you have to state anything? I do not want to adduce any evidence. I was sleeping at night. In the morning hours when I woke up, I saw my wife hanging on a tree. I informed the villagers immediately. I am innocent. I have not killed my wife. So here also in these questions, Lordship, there was no question asked whether he and the deceased were together in the room or they slept together, or whether he was there at that night or not. No question has been asked on this. So last scene theory, Lordship, I mean, like there is no question has been asked, specific question has been. So Lordship, I'll take your Lordship to the inquest report. That it is at page 33, your Lordship. Page 34, Lordship may come. The approximate date and time of death is 18/12/18 p.m. Description of injury mark, if any, cut mark on face, blood stain on face, injury mark on eye. But this injury mark on eye, it hasn't come in the post-mortem report here. That I'll show, Lordship. It was not meant, it was not there. Then Lordship, serial number 10, Lordship will find opinion of witness and police about the cause of death and weapon or instrument used thereof, if any. Injuries present on face and also ligature mark seems circular. Suspected cause of death is murder. Medical officer concerned will determine the exact cause of death after postmortem. The inquest was done at 2:30 p.m. on the next date, 19/12/2018. Then page 36, Lordship, that's the seizure list. So Lordship, may kindly note down the time here, page 36. It is place of seizure, residence of Indra Bahadur Limbu of Khalasi. Date and time of seizure, 19/12/2018, 7:50 clock. So whereas Lordship, in the evidence part, as Lordship I have pointed out, ASI stated that like he prepared the seizure list at 9:50 a.m. Whereas he has written here 7:50. I, Jitendra Singh, Patgaon Outpost, hereby seize the following articles mentioned below in connection with the above mentioned case at the place of occurrence, that is residence of Indra Bahadur Limbu, son of so-and-so, in presence of below signed witnesses, description of seizure, an old green plastic rope with a knot at one end. The length of the same might be around 3 meters or more. Then this signatures, Lordship, that witness Arun Limbu is there, and Kesav Chetri. Kesav Chetri has not been, neither the Arun Limbu nor Kesav Chetri, Lordship, we point out, these people are not examined. Neither Arun Limbu nor Kesav Chetri. Because these are the seizure witnesses, but like they have not been examined by the prosecution. Then Lordship, the post-mortem report, most importantly, post-mortem report at page 38. So it was time is 19/12/2018 at 10 p.m. Next page, Lordship will find the external appearance part. Number 2, Lordship will find owns, position and character. Cut is over face 2 in numbers, deep cut so and so. Abrasion is swelling around the neck. The bruise position, size, nature, bruise on face and neck. Abrasion is on neck, swelling. So as far as the eye part, Lordship, that which has been mentioned in the inquest report, eye part, there is no injuries in the eye has been stated in the post-mortem report. The only thing is the cut mark, these 2 cut marks. Then Lordship will come kindly. These are Lordship, these are normal things. I mean, of a date. Post-mortem. Page 41, Lordship will find the injury part. Cut injury over face, 2 in numbers, deep cut. Abrasion is in around the neck, swelling. So abrasion is there. So hanging part is Lordship, the body was hanged. There's no doubt about this because post-mortem has also come and like the body was found hanging. So hanging is not disputed, your Lordship. Then Lordship, page 42, the opinion part. In my opinion, the cause of death is due to severe hemorrhage. It is antemortem in nature. Then Lordship, charge sheet is at page 45. Page 47, your Lordship. The charge sheet in brief is that on 18/3/2019, complainant ASI Jitendra Singh so lost the written Azahar with this PS informing the village headman, informed him that a resident of Palasigaon so committed suicide by hanging herself. Though the complainant was told that this was a case of suicide, but after seeing injury marks on her body, he suspected that it was a case of murder. Later, as an ASI Patgaon outpost, I carried out his duties as per the provisions of law. Later, when PM report was received, and on the basis of the doctor's report, which stated that, in my opinion, cause of death is due to severe hemorrhage, and it is antemortem in nature. The OC of the police station registered a case bearing case number so-and-so, IPC, and a case was investigated. In the course of investigation, the place of occurrence was visited, a sketch map of the same was prepared. Statements made by the complainant as well as the witnesses were recorded and got the seizure endorsed seen in connection with the case. Following that, as the accused was found to be involved in the case, he was arrested. Necessary measures have been taken in order to investigate the case. During the investigation, based on the statement of the complainant and the witnesses, the case was found to be well established against the accused 302 IPC. The charge sheet is being submitted to the Honorable Court for holding a trial. The witness mentioned in column 16. So charge sheet was filed. Then also one very important document which was not before the trial court, but it may be relevant here also for this case. Page 53 here. The prosecution case is that lordship, that they didn't have any children. They were childless, and the both of them were seen together in the room. So that was the prosecution case. Now, lordship, this document says this is a document which has been written to the Honorable Chief Justice Guwahati High Court, Guwahati, by the accused, lordship, Indra Bahadur Limbu. Here, lordship, what it says is that the humble submission before your honor is that on 13/12/2019, the Honorable Sessions Judge Kokrajhar convicted me in Sessions case so and so for committing murder and sentenced me to undergo rigorous imprisonment for life. I have a minor son aged about 10 years and a minor daughter aged about 5 years. There is none in my family to look after them except for me. So this is a letter written by the accused. So he says that he has 2 minor sons. So that means they were there with them at the day of the occurrence. And police investigation hasn't done anything to find out this fact. They haven't cross-examined or examined these witnesses properly. So lordship has seen, I have read out those evidence parts. Very short evidences, very small, short statements they have taken. It was not properly investigated. There is one witness. There is a statement that's stating that they didn't have any children. That lordship will find. The Bhimdos Limbu's evidence, lordship, page 15. Dear lordship, there is a mention at page 16 in the cross-examination part. She had no children. But lordship, this letter really surprises me, because it says 2 children, in fact, 10 years and 5 years. And the incident happened in 2018. And this letter was written in 2020. And the minor son is aged about 10 years and 5 years. So that means the children were there at that point of time when the incident happened.
Incident took place on 2018.
2018, your lordship. That FIR is at page 4, your lordship. The 18/3/2000 to 2019 FIR was filed. So the incident happened on 19/12/2018. So
Lordship, may I interfere in the point, your lordship? I've just gone to the case, I shouldn't say, but lordship, the statement of the accused person is there, wherein he has elaborately stated about his children, my lord. He says, my lord, about 3 years he got married with the deceased.
Where is that?
No, it's in the case diary, it's not on record.
Oh.
Just in order to clarify that issue. Tair pora mur kono khoti khantoti nai. I do not have any children out of the marriage with the deceased, my lord. Ami do kodai mot khao, that apart, lordship, regarding the issue of children. Mur lora eta aru swali tinijoni ase. He is having 1 son and 3 daughters, maybe from the earlier marriage, my lord. Lorar Garrison Limbu, Dangor Solijoni Nam, Tulki Limbu, Tai Horolpra, Ditio Solijoni Sanjala Nipu, Tai Kosugaut Bia Huise. So they have got married, my lord. Ditio Solijoni Nam Hol Anjana Limbu, Tai Nijor Bhoni Khor Horolpra Taki, Porahuna Kori is a third girl resides with her sister who got married. Jua English so and so Tarike most treason so that is not material, my lord. Regarding the issue of children, just I wanted to verify, my lord. It's in the
So-
case diary. They have
So
yes.
they have children. So that means, lordship, last seen theory on the basis of which that
No, not they.
lordship
With the disease,
Yes.
Yes.
he had no children.
with the disease may not be, but children were there.
No, they
No, the children was staying with the
yes.
aunt. Aunt
Yes.
or what?
No,
No.
sister from the maybe from the earlier mother.
Hmm.
This is little bit contradictory, lordship. Because here it says the ages are, ages have been mentioned in this letter. I have a minor son. This is on 7/1/2020. He says that like, I have a minor son aged 10 years and a minor daughter aged about 5 years.
Maybe from an earlier marriage.
That's true, but like as far as the case diary is concerned, let's say what the statement, 161 statement, it says that like one daughter is married, one son stays somewhere else, and another daughter stays with the sister. So like, now here the mention is of a minor son. And is it about 10 years and a minor daughter is it about 5 years? So this is little bit, I'm not sure, let's say this is little bit contradictory, but whatever way. And this has been written to the Chief Justice by him. As far as like this letter
Marriage with the
goes.
deceased has taken place 3 years before the occurrence.
So, incident
Hello?
has taken place on.
So, marriage with the
king.
deceased taken place 3 years before the occurrence.
3 years before.
Yes.
The offense.
So if the children are 5 years or whatever, cannot be from the side of the deceased man.
No, from the disease may not be. From this disease, it may not be. But maybe from the earlier marriage. So this is little bit contradictory. This fact hasn't come properly, also. So there is some kind of doubt now whether someone was there or not. This is 161 statement before the police. So there was some doubt is obviously there, let's say. And there is no eyewitness into this case. It's only hearsay evidence, which all these neighbors are saying that it's found hanging and all. Nobody has seen it. And the last seen theory, lordship, it cannot be a case of last seen theory also, because nobody has seen them. Nobody has come forward to say that like they have seen both this accused and the deceased were together in the room on the fateful night. There's no evidence coming on that. So last seen theory, the whole case is, this learned session judge has given him sentence on the basis of last seen theory and the post-mortem report. And the last seen theory, lordship, it's a different concept altogether, lordship. Last seen theory, somebody has to tell that, oh, I have seen them together. We have seen them together. They were together. Now, in this fact, lordship, I have read out the whole evidence. Nowhere it is coming out that both of them slept together. So he doesn't have any alibi. So nothing like that, lordship. And 161 statement, he says that they were sleeping and like suddenly he found out in the night that she was missing, and he saw that she was I mean, in the morning, he saw that she was hanging on the tree. So only on the basis of last seen theory, Lordship, a person cannot be
PW 6 and 7.
PW 6 and 7. Yes, your Lordship.
Said her feet was touching the ground.
Yes, that part is there, Lordship. I have read out. The touching the grounded part is there.
6 and 7.
Yes, Lordship.
Okay.
That is there, Lordship. That part is there. That part is on record, Lordship. Touching the ground. But Lordship, first thing is that like whether the seizure was done properly or not. Seizure list was whether prepared on the place of occurrence or not. That I have already pointed out, Lordship, because where the witness says that when at 7 a.m. the police has already left the place. I'll just point out, Lordship. That PW6 only, Lordship, will find. PW6 at page 16 in the cross-examination part, Lordship will find in the bottom paragraph, the last 3 lines, Lordship. The police team had returned from the place of occurrence at about 7 a.m. Whereas this seizure list was prepared, supposedly prepared at 9:50 a.m. as per the PW4 force evidence, Lordship.
He was not a witness to the seizure list.
He was not. That these 2 witnesses were there, they were not examined. 2 witnesses, seizure list witnesses, they were not examined. It's a huge lapse on the part of the prosecution. Huge lapse. Only the neighboring people, they have, they have taken the evidences of the people who were neighbors, and only the hearsay evidence. There is no eyewitness to this. And the seizure list witnesses were not called for. He has specific. So this means, Lordship, the seizure list was prepared somewhere else, maybe in the police station. So this is very clear, Lordship. Page 13, PW4 himself stated. I have not mentioned that it is this accused who committed the murder. Exhibit 3 seizure list. I have not taken the signature of the Gaubura. Gaubura is the person probably, Lordship, who has informed. But he was present, but his signature was not taken. The seizures witnesses Exhibit 3. Arun Limbu has stated in his statement under so and so that he signed this. Other witnesses have also signed at 9:50 a.m. It is not a fact that exhibit. So 9:50 a.m. the seizure list is supposed to be made, but as per the PW6, they have already left the place at 7 a.m.
Just see that 161 statement.
Yes, it's mentioned at 8 a.m. My lord, seizure was done.
Arun Limbu. Arun Limbu.
Gosh. Uh, 9:55 a.m. your lord. Nine
9:55.
Yes, my lord.
So it must have been prepared in the police station itself. It was not prepared at the place of occurrence. A huge lapse, sir. Big lapse.
Lordship, this witness, he was not a seizure witness, my lord. So like, just like that he might have stated before the court, my lord, about the time. It is a serious lapse. The lordship will take into account that part. He received the information at 10:20 AM. ASI Jitendra Singh received the information. Let him complete his part.
The Jitendra Singh Lordship, in his evidence, he has very clearly stated that I went to the place of occurrence at 6:30 AM in the morning. Page 13, your lordship. Page 13, your lordship, on the top only. I went to the place of occurrence at around 6:30 AM.
Yes.
Very clearly he stated at 6:30 AM. So there is no question of any doubt about this. 6:30 AM he went there. Then the another evidence PW6 has stated that the police left the place at about 7 AM. So there is some doubt, lordship, in this.
It's only doubt or it's relevance is there.
It's relevant because lordship, it's a lapse on the part of the prosecution, because if on the place of occurrence they haven't made the seizure list, and whether the seizure was properly made or not, it cannot be made out from this record. Now, lordship, this case is only this case is based only on the theory of last seen theory and the medical evidence. Medical evidence,
Learned trial court said it's more than that.
lordship.
It's more than that. It's much more than the last sin theory.
No, lordship, I'll take your lordship to what lordship, let us see, lordship, what he has stated. His findings are, lordship, page 29, your lordship will find.
23.
Yes, page
Here
20.
the last sin theory is much more than that.
No, last seen theory is much more than that because they were in the same room. That's what he's meaning. He's not saying about that like public place or something like that. But there is no evidence coming, lordship. There is absolutely no evidence that like they have been seen to last seen together. I mean, if you do not have any material on that, how can you place reliance on that? It's totally absurd, your lordship. Last seen theory, how last seen theory can be brought in when no witness has stated that like they were together? Nothing is on record, your lordship. Only on the basis of medical, post-mortem report, there is an opinion that it can be a case of not a suicidal, maybe it's an anti-mortem case. So only on the opinion whether how much reliance can be placed, I will place a case record of the Supreme Court, case of the Supreme Court, how much reliance can be placed on this medical evidence when there is no other evidence.
What about the evidence of PW 6 and 7?
PW 6 and 7, here's the evidence again, lordship.
No, they saw the body.
They saw the body, lordship, but they
touching
haven't.
the
But they have not.
fish was touching the ground.
That is true, lordship. But touching the ground, it may come down also later on. A human body, adult body, only on a rope. So, lordship, if the body was, she hanged herself sometime 5-6 hours ago, then a body may come down also. It can touch the feet also. Like death theory cannot be ruled out, lordship. Whether it can be ruled out, that a adult body on a tree on a simple rope, it may come down after later on also. If it is hanged for 5-6 hours, it may come down also, lordship. But there is no direct evidence. Seeing someone like dragging her body, the accused dragging her body, then tying the rope, then hanged her body on the tree. There is no evidence coming on that. It's all presumption, lordship. Prosecution could not bring in all these factual things. There is no material. Only hearsay evidence that like we got to know that she got herself hanged, she was found hanged. All this kind of evidence, lordship. And like last seen theory, lordship, I could have understood. Then somebody has come and stated that both of them were seen together in the same room. There was nothing like that. And 313 examination of the accused also, there was no question put on that regard. At least there should have been a question on that regard to find out whether he has any kind of explanation to that. Nothing has come out. No, I have read out, lordship, there is no question put to him. There's no question put to him. At least one question should have been there. Lordship, in my humble submission, the prosecution has totally failed to bring home the case for prosecution case. So I'll place, Lordship, couple of judgments, Lordship, of the Supreme Court. So this is a case of purely, I mean, session judge, learned session judge has totally relied on the postmortem report. Whether in case of there is no other evidence, how much, trust can be given to the postmortem report. This is Supreme Court cases, Lordship, I have just pointed out. The paragraph 21 here, Lordship, will find. This is, Lordship, 2013-10 SSC 298. Paragraph 21, Your Lordship. So it says, Lordship, doctor's evidence may be significant. It may not be insignificant, but it's not a substantive evidence. So I'll just read out the paragraph here, Lordship. Paragraph 21. It is true that postmortem report is not a substantive piece of evidence, but evidence of such doctor cannot be insignificant. The court in state of Haryana versus Ram Singh held under, while it is true that postmortem report by itself is not a substantive piece of evidence, but evidence of the doctor conducting the postmortem can by no means be ascribed to be insignificant. The significance of the evidence of the doctor lies vis-a-vis injuries appearing on the body of the deceased person and likely use of the weapon, therefore, and it would then be prosecutor's duty and obligations to have corroborative evidence available on record from the other prosecution witnesses. So full reliance of the postmortem report has to be done very carefully. So some corroborative evidence the prosecution should bring in. But in this case, Lordship, I could not find any corroborative evidence as such. Only thing is that there are some cut marks on the face and there's an abrasion on the neck and the opinion of the doctor. There is no other evidence which is coming out. Another case, Lordship, on postmortem report. This is, Lordship, 2012-11 SCC 685.
Yes.
It's a short paragraph, Lordship, paragraph 9. It is also on the, postmortem report. The High Court has para 9. The High Court has also relied upon the postmortem report of the doctor. In our opinion, since the entire evidence of the eyewitnesses has not been accepted by the High Court, it could not have merely relied upon the postmortem report to convict the appellant for an offense under Section 302 IPC. Further, in our view, the postmortem report should be in corroboration with the evidence of the witnesses, eyewitnesses, and cannot be an evidence sufficient to reach to the conclusion of convicting the appellant. In view of the above, we have no other alternative but to allow this appeal and set aside the judgment and order passed by the High Court in convicting the appellant for an offence punishable under section 302. So it has also specifically, Lordship, stated that it cannot be an evidence sufficient to reach conclusion for convicting the appellant. So postmortem report, only on the basis of the postmortem report, if other evidences are not there, corroborative evidences are not there, then it can, I mean, a person cannot be held responsible for committing an offense of murder. Then the last case, Lordship, that's 2016 1 SCC 550. So this is regarding that last scene principle, Your Lordship. Paragraph 14 and 15.
Yes.
That the courts below convicted the appellants on evidence of PWs 1 and 2, and the deceased was last seen alive with the appellants on 23/1/2001. Undoubtedly, the last seen theory is an important link in the chain of circumstances that would point towards the guilt of the accused with some certainty. The last seen theory holds the courts to shift the burden of proof to the accused and the accused to offer reasonable explanation as to the cause of the death of the deceased. So this is what I was, Lordship, pointing out, that he was not asked put a question about this aspect. So this shifting of burden was never done. I mean, the burden should have been shifted to him. He should have been asked about an explanation, proper explanation, but that hasn't been done. The last seen theory holds the courts to shift the burden of proof of the accused and the accused to offer a reasonable explanation as to the cause of death of the deceased. It is well settled by this court that it is not prudent to base conviction solely on the last seen theory. Last seen theory should be applied taking into consideration the case of the prosecution in its entirety and keeping in mind the circumstances that precede and follow the point being so last seen. So then, Lordship, they elaborated the case of state of Rajasthan, paragraph 15, elaborating the principle of last seen alive in state of Rajasthan versus Kasiram. In this court held under so and so, it is not necessary to multiply with the authorities. The principle is well settled. The provision of section 106 of Evidence Act itself are unambiguous and categorical in laying down that when a fact is spatially within the knowledge of a person, the burden proving that fact is upon him. Thus, if a person is last seen with the deceased, he must offer an explanation as to how and when he parted company. He must furnish an explanation which appears to the court to be probable and satisfactory. If he does so, he must be held to have discharged his burden. If he fails to offer an explanation on the basis of facts which within his special knowledge, he fails to discharge the burden cast upon him by section 106 of the Evidence Act. In a case resting on circumstantial evidence, if the accused fails to offer a reasonable explanation in discharge of the burden placed on him, that itself provides an additional link in the chain of circumstances proved against him. Section 106 does not shift the burden of proof in a criminal trial, which is always upon the prosecution. So this says, Lordship, that section 106 does not shift the burden of proof in a criminal trial, which is always upon the prosecution. So prosecution should have proved it. It lays down the rule that when the accused does not throw any light upon the facts which are spatially within his knowledge and which could not support any theory or hypothesis compatible with his innocence, the court can consider his failure to adduce any explanation as an additional link which completes the chain. The principle has been succinctly stated in so and so. So Lordship, in this case, though last seen theory has been totally applied by the learned session judge, there was no question put up. He was not given an opportunity to explain this theory before coming to a conclusion by the sessions court. So it's a total failure, Lords, total failure on the part of the prosecution. Prosecution could not bring in any evidence stating that these persons were together. The page 30 of this judgment, your Lordship, is a specific finding. How can this finding, how can the learned session judge can come to this finding, Lordship? It's a specific finding stating that the accused and the deceased were last seen together inside the house. From where it has been stated?
Because they are husband and wife, natural.
that finding I found it very surprising, because how come he has come to a finding without having any material on that? There is no material, there is no evidence coming, there is no statement of anybody that both of them were last seen together. And there is no eyewitness in this case. So in these circumstances, Lordship, I think this is a fit case for acquittal of the accused, dear Lords. So I pray for an acquittal, dear Lords. That's my humble submission.
Lordship, may I do this? Apart from the appreciation made by the learned trial court, your Lordship, regarding last seen theory, at this appellate stage also, your Lordship may appreciate and reappreciate the evidence on record, your Lordship. First, I take your Lordship to the evidence of PW1 regarding the conduct and whether the nature of the accused person, my lord, and how was the relation, what is the relation between the accused and the deceased, my lord. PW1, your Lordship. Who is the Gaubura, my lord? PW1, page 9. I know the accused. Oh, she's not a Gaubura. She's just an acquaintance, my lord. I know the accused. Accused is an alcoholic and he used to quarrel with his wife every night. This part will Lordship will continue. He was an alcoholic and he used to quarrel with his wife every night. Then, your Lordship, evidence of PW 2 and 3 are not relevant. Lordship, PW4, my lord. The IO, my lord. Page 12. On 19/12/2018, I received an information from the Gaubura of Patgao that the body of Nepti Limbu, wife of accused, is found hanging on a tree. After getting the information, I went to the place of occurrence along with police team and found that the local villager had brought down the dead body. I immediately informed the officer in charge of Sarfanguri police station, and an unnatural death case was initially registered as UD case number so and so. The dead body was sent for postmortem examination. The PM report revealed that the death is due to severe hemorrhage and it is antemortem in nature. Your Lordship will kindly note the PM report, my lord. The death is due to severe hemorrhage and it is antemortem in nature. Further, the inquest of the dead body was also done by executive magistrate. Exhibit 2 is the inquest report which was forwarded to me by the executive magistrate. On the basis of inquest and the PM report, it appears that the death of Nepti Limbu was homicidal and accordingly I lost the FIR. Then the evidence of the doctor, my lordship, I'll take your Lordship the cross part also. I went to the place of occurrence at around 6:30 a.m. in the morning. The Gaubura told me that the rope lying near the dead body was the rope on which the body was hanging. The witnesses present at the time informed me that accused and his wife used to quarrel with each other and both of them were alcoholic. So this was done at 6:30 a.m. on the basis UD case, my lord, because at first unnatural death case was registered, your Lordship. I did not see any mud on the body of deceased. The wearing apparel of the deceased was not torn. In the FIR Exhibit 1, I have not mentioned that it is a accused who committed murder. In Exhibit 3 scissor list, I have not taken the signature of Gaubura. The scissor witnesses Exhibit 3 is Arun Limbu has stated in his statement under 161 of CRPC that he is signed in a scissor list. But Arun Limbu, Lordship, he was not examined as a witness, my lord. It is not a fact that Exhibit 3 is so and so. Then, your lordship, evidence of Dr. my lord PW5 at page 14. On 19/12/18, I posted as medical and health officer at RNB Civil Hospital, Kokrachhar. On that day, on police requisition, I had conducted postmortem examination of the deceased Nepti Limbu, aged about 50 years, and my observation are follows. Cut injuries over phase 2, numbers in deep cut 3 into so and so such abrasion, injury, swelling around neck. So these are the injuries, my lord. Cut injury over phase, deep cut so and so injury, and abrasion, injuries and swelling around the neck. Injuries are sufficient in the ordinary course of nature to cause death. Your lordship will note that part, my lord. Opinion. In my opinion, the cause of death is due to severe hemorrhage and it is antemortem in nature. I did not find any scratch mark in the body of deceased Nepti Limbu indicating that she has been dragged. Then the evidence of PW6, the evidence of 6 and 7 proves that accused person was at the residence, my lord, at his residence. He only reported PW6 and 7 about the matter. PW6, my lord. I know the accused. About 4 months back, accused came to our residence and informed me that his wife Nepti Limbu is hanging on a tree behind his residence. So he was at the place of at his place, my lord. I went to the residence of the accused and saw that Nepti Limbu is hanging on a tree, but her feet was touching the ground. Apart from the PM report, as my learned friend was making submission, apart from this PM report, my lord, they were witnesses, they have seen that the dead body of the victim was touching the ground, my lord. I had seen blood mark on her body. I immediately informed the in charge Patgaon police station. Then the cross part, my lord. It is not a fact that I have not stated before the police that I had seen Nepti Limbu hanging on a tree, but her feet was touching in the ground. It is not a fact that I did not inform the in charge of Patgaon police outpost. I knew that Nepti Limbu was an alcoholic. She had no children. Nepti Limbu was a short-tempered lady and she used to threaten the accused that she would leave his society. Police team had returned from the place of occurrence at around 7 a.m. I do not know the nature of investigation conducted by police at the place of occurrence. I personally do not know how Nepti Limbu died. Then the evidence of PW7, my lord. Sonu Subba. I note the accused at page 17. Has your lordship got it, my lord? About 4 months back, accused came to our residence and informed me that his wife Nepti Limbu is hanging on a tree behind his residence. I went to the residence of the accused and saw that Nepti Limbu is hanging on a tree, but her feet was touching the ground. I had seen blood mark on her body. So, your lordship, these witnesses also deposed that her feet was touching the ground and there was injury mark, my lord. Then the evidence of PW8, my lord, the IO. Page 18. On 18/3/19, I was posted under Patgaon police outpost. On that day, I was entrusted with the investigation of this case. In the course of investigation, I visited the place of occurrence. I had recorded the statement of the witnesses, also took steps for causing the postmortem of the deceased Nepti Limbu. After getting the postmortem report and having found sufficient materials against the accused Indra Bahadur Limbu, I submitted charge sheet against the accused Indra Bahadur Limbu for the offense under 302 IPC. Exhibit 5 is a scissor list prepared by me, by virtue of which I have seized a piece of rope. So and so is a charge sheet. The accused was not in the FIR. PW4 Sri Jitendra Singh did not state before me that he received information from the Gaubura of Patgaon regarding the death of Nepti Limbu. The statement of PW4 Jitendra Singh was recorded in the Patgaon police outpost. PW6 Himdhoz Limbo stated that he received the information on 18/12/18. PW7 Sonu Subba stated that on 19/12/18 she came to know about the date of Nepti Limbo and went to see her dead body. In the Caesar list Exhibit 5, the case reference has not been mentioned. The Caesar list Exhibit 5 does not mention from where ASI Jitendra Singh found the rope. It is not a fact that seized articles by the Exhibit 5 is not connected with the case and it is a seizure in connection with some other case. It is not a fact that Nepti Limbo's death was suicidal, not homicidal. It is not a fact that I have not investigated the case properly. Then, Your Lordship, the 312 statement made by the accused person. Other questions are not relevant except answer to question number 11 at page 21. I do not want to adduce any evidence. I was sleeping at night. In the morning hours when I woke up, I saw my wife hanging on a tree. I informed the villagers immediately. I'm innocent. I have not killed my wife. So he was present at his residence. When he woke up, he went maybe into the backside according to Trivanti's statement regarding the presence part. I'm submitting, my lord. He was very much there at the place of occurrence, my lord. So your lordship, if it's not a case of prosecution, but your lordship, from the circumstances that the injury was there on the body of the deceased, my lord, and your lordship, the injury was not lordship suicidal, it was homicidal as per the medical doctor, my lord. So lordship, if something would have happened in his residence, lordship, the accused person, if third person would have come and attacked the deceased, my lord, he would have naturally be the witness to the occurrence, my lord, as he has done, committed the crime, and your lordship, as per the evidence of the village people, it's a regular practice, my lord, fight and all, and they were alcoholic, my lord. This specifically the accused person and the deceased also, your lordship. So it's a regular habit, your lordship. Every night they used to fight. So lordship, the village people might have come to a conclusion, my lord. It's a regular fight, and as a result of which they did not come, my lord, because every night they used to fight, my lord. And your lordship, and it's not the case of defense that he was not at the place of occurrence, your lordship. If he would have been, it's his own statement, my lord, in 313, as well as he's the reported witness to PW, lordship, PW 5 and 6, that he was very much at the place of occurrence. So it can be assumed from the circumstances, my lord, he was the perpetrator of crime, my lord. Regarding the postmortem and the lordship inquest report, may I take your lordship to the postmortem report first? Page 38, your lordship. Page 39, wounds, position and character. Cut is over face, two in numbers. Deep cut, so abrasion and see swelling around the neck. Bruises on face and neck. Then abrasion is on neck, swelling. Then your lordship, opinion of the doctor. Injury, page 41, my lord. Muscles, bone and joints. Cut injury over face, page 41. It's handwritten, my lord. Cut injury over face, two in numbers. Deep cut, 3 into 2. Abrasion is around the neck and swelling. And opinion. In my opinion, the cause of it is due to severe hemorrhage and it is antemortem in nature. Then, my lord, inquest report at page 33. Page 34 is related. Position of dead body, hanging position. Description of injury mark, if any, cut mark on face, blood stain on face, injury mark on eye. Lordship, then my lord. Opinion of the witnesses and police at serial number 10. Injuries present on face and also ligature mark seems circular. So your lordship cannot be suicidal, my lord. When ligature mark is circular, your lordship. Suspected cause of death is murdered. Medical officer concerned will be determined the exact cause of death after PM. So as per the evidence of medical doctor is also its lordship homicidal in nature. Postmortem report coupled with the inquest report, coupled with the injury part, there would not have any injury on the face and neck if the deceased had committed the suicide, your lordship. Coupled with the evidence that he was very much there at the place of occurrence, my. So burden shifts on him under 106, my lord. Reverse burden shifts on him, my lord, under 106. He should have explained, my lord, under what circumstances. Although he said, my lord, he was present, he was sleeping. He did not make any endeavor, your lordship, or to give any defense witness, like some other persons came and committed the injury, my. There are discrepancies as regards the, my lord, non-examination of the material witnesses and regarding the noting regarding the time, my lord, but I don't think it's fatal, my lord. Proof the guilt against the accused person. I have nothing more to say except your lordship will uphold the conviction part, your lordship. Taking into the circumstances, my lord. Lordship, although last in theory cannot be, my lord, but your lordship may still reappreciate the evidence on record and uphold the conviction. He did not say he was not there at the place of occurrence. He only went and reported. In 313, he said he was sleeping, my lord, and woke up and saw, my lord. So he was very much present, my lord. That is my response.
Only one aspect, lordship, that as far as this witness and evidence of the witness number 4, that IO, that he stated that I did not see any mud on the body of the deceased. The wearing apparel of the deceased was not torn. So if lordship, I mean, two adult fighting and somebody was killed and all the clothes are perfectly fine. And her body was taken to a tree in the backyard and there is no mud mark, nothing. So can it be, lordship, like, is it possible? Like, I mean, I was questioning myself, is it possible? I mean, two adults fighting, there is no, I mean, the clothes were perfectly fine. There is nothing in that. Then the body was found in the backyard and like hanging and like there is no mud, there is nothing, no dragging. I mean, this is a little bit, I mean, so there is, I mean, there may be a case of suicide also. That's what. And there is no explanation of there is no need of stating any other explanation about somebody else coming out and like doing something wrong, because it's a case of suicide. My explanation is that like I found the body on the backward hanging. It's a case of suicide. That's
I reply to the query made by my learned friend, your lordship, it's done with a systematic manner, that everything would be proper, your lordship. But your lordship, the body was touching the ground. That is the aspect your lordship may take into account.
that explanation, lordship, I have given. That body is hanged and like it's a plastic robe. It's always touchable.
Elastic is stretchable, plastic may not.
Plastic rope, it comes down after the plastic rope takes the weight for some time, it may come down. It cannot be ruled out, Lord. It cannot be ruled out.
Lordship may upheld the conviction after going into the.
Give your reasons.
Lordship.
I'll also.
When can we give?
Maybe we in a week, lordship, week's time.
Then we'll keep it part-time. Heard a Kalita Leonard is given. Also heard MSP Boyan. Yes. Working back. This for the You list it on 5th.
Monday.
We'll list it on 2nd because brother will not be there.
Second is Friday, man.
Friday.
Yes.
Is it possible?
Well, lordship.
Only the written submission.
Right,
nothing
lordship.
more.
Lordship, item number 13 is also, lordship, may I pray for some time in this? This is like a case regarding NDPS. It's a subject new to me, lordship. I'll have to prepare the case little. I don't know what 13.
Kalita Leonard is given. Is the matter after
2 weeks, lordship, 2 weeks time minimum.
after 2 weeks.
2 weeks.
Lordship, liberty may be given to me. If I find some citation, I'll give the citation with my written out.
Obliged.
Well,
May I please, your lordship? I'm assisting as an amicus curiae in this matter. My lord, this is a conviction for life imprisonment, rigorous imprisonment under 302, section 302. Before I take your lordship to the evidence part and other things, here I found something strange during the 313 statement. The accused made a statement, may I just take your lordship, page 25. The accused killed his elder brother. Page 25. Question number 8. Do you want to say anything else? Will you adduce any evidence on your behalf in the case? My elder brother was drunk on that night and I got angry with him and could not resist my anger. I took his spade in my hand and killed Amal Barak. I will not adduce any evidence in my defense. So when I saw this statement of the accused, I make contact with the jail superintendent to find out the mental status of this, because nothing on record, nothing is there to ascertain the mental status of the accused person. And surprisingly, the jail superintendent has given me 2 recent prescription of the accused person who is suffering from schizophrenia. The jail superintendent had no other document because he is undergoing medical treatment at the LGB Regional Institute of Mental Health at Tejpur. The jail superintendent, this is the jail copy. They took a photograph and forwarded to me. 2 prescriptions, and every month he is going this LGB Regional Institute of Mental Health at Tejpur. Now I tried to find out for which purpose these medicines have been given. And if your lordship will take page 3, these medicines are for treatment of schizophrenia. So these are the 2 latest medical prescriptions, which indicates that the accused is suffering from schizophrenia, and the accused present age is around 32 years, and the incident occurred in the year 2019. So nothing is on record to And even the learned trial court has not tried anything to ascertain the mental status of the accused. While he answered in that way, just my elder brother was drunk on that night. I got angry. I cannot resist myself, and I took a spade and killed my brother. This is something very unusual. Well, it was a duty casted upon the learned trial court under section 328 to ascertain the mental status of the accused. And this is the only basis on which the trial court has convicted him. And the others are all circumstantial evidence. Nobody has seen him to kill his elder brother.
Yes.
My lord, in my humble submission, in this appellate court under section 391 of CRPC has the power to ascertain, to take further evidence or direct to take further evidence, right? To ascertain the mental status, because we don't know at that 2019 whether he was suffering from this schizophrenia or not, because the court, the trial court has not made any endeavor to find out whether he is of sound mind, despite saying that I have killed out of my anger, nothing else. A prudent man, only because the elder brother came drunk, that is why I have killed my elder brother. And now this medical prescriptions from the jail authority indicates something is there. And in my submission, your lordship may direct the LGB Regional Institute Mental Health to submit a report regarding his previous history of the accused person.
Now, if I may say, there are two aspects of the matter. One is during the time of the occurrence, whether he had some unsoundness of mind. That lordship will have to see the legal insanity, not medical insanity. So legal insanity will be seen, can be gauged from his actions immediately before and after the occurrence. This is one aspect of the matter. Here, I've gone through the evidence. What I can see is post occurrence, he might be suffering from some legal insanity because he was chasing with the same spade with which he had hit the deceased to others also, to the other persons who had come by there. So legal insanity, seeing the legal insanity during the time of occurrence is one aspect of the matter. Second, what my learned friend is saying about his insanity now or during the trial, then section 328-29 will come. Trial needs to be postponed and all. From the judgment, it is not clear whether that exercise was at all taken. But from the order sheet, there may be something because he has been taking treatment since long. Now at this stage, once Chief Justice Ajit Singh had the occasion to deal one of such cases, and what he did is he had called for a medical report, a history of the patient from the jail doctor since the date of occurrence. And after seeing that entire history, then again the case was taken up in order to see whether at the time of occurrence there was legal insanity. I may see the order sheet first, whether that aspect was at all taken, noticed by the trial court. Otherwise, judgment I don't find anywhere
Nothing is there, nothing is there.
saying that he had suffered something. Order sheet, I'll just see once. Otherwise, legal insanity is also difficult. Immediately before the occurrence, there is no evidence. They both were there together. There was a fight, and then he had hit him. And when the people came, he was showing to everyone the spade that he was holding, and he was chasing them away. That part, okay, his conduct shows. That conduct was taken as a relevant factor under Section 8 of the Evidence Act by the trial court, but not for deducing the fact whether he was mentally unsound.
My lord will take note of the disease as reflected from this medicines. This is schizophrenia. The attack of schizophrenia comes occasionally. It's not like other diseases, mental diseases, that continuously it will be shown. Maybe, perhaps, I don't know, because at the time of incident, he may have the attack of schizophrenia and he was not treated. But that aspect, before going into the merit, that was not dealt by the trial court at all.
Schizophrenia cases also, my learned friend cannot say that since he is suffering from schizophrenia, he has mental unsoundness or he is suffering from legal insanity. That will be seen from the facts of the case. Even patients who had schizophrenia at the time of occurrence were not considered for acquittal and all, because at the time of occurrence, he didn't have that. So we'll have to again see the facts of the case. Now in the order sheet, of course, he was never on bail. He was in jail throughout, and his mental thing was not taken into account. I don't think so, no. He was given the service of a legal aid counsel and then nothing. The accused has not complained of any injury. He is informed as he is entitled to legal aid. Yes, in the order sheet, there is none.
Since when he has been taking his, my lord, as informed by this jail superintendent, he has been posted there in 2021 probably. So he could have laid his hand only these 2 prescriptions only. The rest of the medical reports and other things are kept in the custody of the LGB Regional Institute of Mental Health, Tezpur. Because the jail authorities are never given any report of the patient. They are only given a copy. Lordship will find JC is written on the top, if a copy of the prescription, nothing else. So LGB Regional Institute of Mental Health will be the competent authority to put some light on this issue. Oh, this Mental Health Institute, Tezpur. He is undergoing treatment every month. Naina?
There is nothing in the records. So what my humble submission would be, Lordship can call for a history of the medical report from the jail doctor from the date of occurrence. 2019, he was arrested on
2019.
huh?
2019.
When did the incident occur?
26/5/2019 he was forwarded.
26/5. Incident was 26/5/2019. Nobody has heard about any quarrel between the two brothers. Nobody has seen the accused of that he is killing. No eyewitness, nothing.
No one has uttered about his unsoundness of mind.
Nobody has
None of the
uttered that also.
witnesses. None of the witnesses have said that.
But Mr.
Edhar.
Edha. Amicus curiae. Also heard MSF now. And the action yes, stop. During the course of hearing, Mr. Edha, learned amicus curiae, has produced the prescription in respect of the appellant issued by the LGB Regional Institute of Mental Health. Stop. The medicines prescribed indicates that such prescriptions are given to patients with schizophrenia. Stop. Para. In that we have to let it come. The jail doctor, of which jail
Tejpur Central Jail.
of Tezpur Central Jail is directed to give a full medical history of the appellant, namely
Rajesh Barai.
Rajesh Parai.
Rajesh Bairai.
B-O-R-A-I-K.
B.
B-O-R-A-I-K.
Borai.
Boraik.
Rajesh Borai. From the date of incident, I 26/5/2019 up to date. Stop. How long will you take?
My lord,
2-3 days, next week, Lordship will take it up.
We'll give you 2 weeks. Don't
Lordship,
think if
yes.
you require some other.
Lordship, another thing, whether this mental health institute, that is mental hospital in Tejpur, because the patient, the accused is undergoing treatment under them.
No, it doesn't matter. The jail superintendent will bring all the reports and
My lord,
give it to us.
Please come back of 2 weeks.
In case he was suffering,
Incident is of 25/5 or 26/5?
26/5 he was
26/5.
forwarded.
The incident took 25/5.
25/5, yes.
25/5. I'm sorry, ma'am. I'm sorry.
In case he was suffering and the trial went on, then the trial will also get vitiated because it was not postponed and all. That we will see again after the records come.
Obliged.
Fifteen is around 15. Oh.
Fifteen.
Your lordship, this matter will be taken up as last matter, last item.
Why?
Last item, my senior is in other,
Who's your senior?
SB Chaudhary.
Where's the appellant's counsel? He was here to courtroom, my son. E.B. Bora was there.
Sorry, sir. I thought it's 14. Sir, I'm appearing on behalf of DP Bora.
Yes.
Sir, my senior is in leg on court number 1. So the matter may be passed over for time.
Okay.
Obliged.
16 and 17.
No. None appears for the parties. This matter after 2 weeks.
15.
Take it up at 2 o'clock. We'll take up.
Was born on 15/9/2010. Further case of the petitioner is that after a few months of marriage, he took the respondent to his the then place of posting at Krishnanagar, Nadia, West Bengal, along with his widow mother. And at that time, he found that the respondent used to doubt him if he would talk with any other woman and even with his mother, for which he and his mother requested her with folded hands to let them live peacefully without doubting the holy relationship between son and mother. But she did not pay any heed to it. Rather, from her conduct, it appeared that she had no feeling for her husband, and her rude behavior increased day by day, and it reached in extreme stage after birth of the son. The petitioner also stated that on several occasions, the respondent told him openly that she had affairs with a boy prior to her marriage with him, and she was interested to marry that boy, but due to the objection of her mother, elder sister, and brother-in-law, she failed to marry that boy. Yet he tried his utmost to satisfy the respondent, providing everything she wanted, but her habit to remain upset did not change. The petitioner also stated that the respondent was so arrogant that she even used to refuse to take medicine while it was necessary, and gradually she started to abuse using filthy languages against him and his mother. And on many occasions, she threw off household articles towards him and his mother, and thus she used to ill-treat him very badly without any cause or reason. And for the last few years, she started pressurizing him to free her from his marriage tie. The petitioner further stated that while he was posted at Masimpur Silchar Kasar, he informed the misbehavior of the respondent to her family members, but they did not try to solve the problem. Rather, they threatened him, and thereafter, in the month of January 2011, on the date of death of his uncle, the respondent left his house and started to stay in her brother-in-law's house and returned to his house after 1 month. That is after completion of all after-death formalities, Shraddha. And from that very date, she avoided him from physical relationship with her and even did not allow him to touch her body. And she started to talk with someone on mobile phone for unlimited time in his absence, and used to leave his house and return on late night or on next day on plea to see her mother, but on inquiry it appeared false. The petitioners also stated that the respondent on several times made written complaint against him before his higher authority on some false allegations, and even she did not take care of their child and used to beat the child habitually without any cause or reason, and even she did not provide food to the child time to time. And due to her negligence and ill treatment, the child gradually became abnormal, and thus the respondent treated him with cruelty mentally and physically. The petitioner also stated that he had filed a suit against the respondent before this court under Section 10 of the Hindu Marriage Act 1955 for a decree of judicial separation by FC number so and so. And after receiving notice, she left his family voluntarily and started residing separately from him since 14/7/2013. Since 14/7/2013, she has left, my lord. And thereafter, the said case was withdrawn by him. The petitioner further stated that since marriage, the persistent and repeated negligence, ill treatment, and misbehavior of the respondent caused reasonable apprehension in his mind that it would be harmful and injurious for him to live and reside with the respondent, and hence he filed this suit seeking a decree for dissolution of his marriage. After receiving notice, the respondent appeared before the court and contested the case by filing written statement and alleged that there is no cause of action for the suit, and that the actual fact is that she was married with the petitioner socially, and after the marriage, the petitioner started demanding a wall TV from her mother as dowry, but her mother could fulfill his demand, for which he started torturing her. The respondent also stated that after about 15 days of the marriage, the petitioner took her and his mother to his place of posting in West Bengal. And at that time, she became pregnant, but the petitioner and his mother used to abuse her in slang language for not giving furniture at the time of marriage, and her mother-in-law used to keep her under lock and key as per instruction of the petitioner during his office hours. The respondent further stated that in March 2010, her mother-in-law brought her to the house of her sister at Silchar and left her there, and in such situation she tried to contact the petitioner over phone, but he used to cut off the line, and hence she contacted the petitioner through his office for taking her, and then he replied that he would take her after his transfer to Masimpur, but he did not take her after he was transferred to Masimpur, for which she went to his residential house at Masimpur and started living there, and thereafter the petitioner told her that he had to go training, and at her advanced stage of pregnancy, it was not possible for his mother to take care of her, and then he took her to her sister's house and left her there. The respondent also stated that on 15/9/2010, she gave birth to a male child, and entire expenditure of the delivery of the child was borne by her sister and brother-in-law, and after delivery, on her pressure, the petitioner took her to his residential accommodation along with the baby, but the petitioner and his mother started torturing her and the baby, and even they did not provide proper food to her and to her baby. Rather, they compelled her to sleep on the floor with the baby on the plea that her mother did not give furniture at the time of marriage, for which she encased her fixed deposit, which was invested by her prior to the marriage, and purchased an alna, one sofa set, one steel almirah, one dressing table, one washing machine, and a showcase to satisfy the petitioner and his mother. But the petitioner started to sleep separately on the plea that his sleep would be disturbed and due to cry of the baby, and when the baby fell ill, she had to take money from her mother for treatment of the baby. But the petitioner did not provide any help for medical treatment. The respondent further stated that thereafter the petitioner was transferred to Karimganj, and they started to live in a rented house. And during Kali Puja, the petitioner took leave to visit his maternal uncle's house with his mother, and she was left at Ramnagar, Silchar with her baby to live in her sister's house at Silchar. And since then, he cut off all relation with her, for which after waiting a month, she came to Karimganj with her baby, but found the house was under lock and key. And at that time, her baby was suffering from fever. And then with the help of persons from his office, she entered the house by breaking the lock and key. And thereafter, she repeatedly requested the petitioner to bring medicine for the baby, but he did not pay any heed to it. For which, finding no other alternative, she brought some homeopathic medicine for the baby. The respondent also stated that after a few days, the petitioner told her that he would divorce her and would marry again, and her mother-in-law also told that they would provide her with so much money she desires if she leaves the company of the petitioner, accepting the divorce. And thereafter, the petitioner filed this suit with false averments, but she is passing her days in starvation with the child. While she has love towards the petitioner and respect towards her mother-in-law, and hence she does not want to get divorced, considering her better future and future of the handicapped child, and as such the instant suit is liable to be dismissed with cause. That on the pleadings of both the parties, issues were framed, which are as follows. Is there any cause of action for filing of the suit? Whether the respondent treated the petitioner with cruelty, whether the respondent deserted the petitioner, whether the petitioner is entitled to get a decree of divorce as sought for, what other reliefs the party are entitled to. The petitioner side examined 2 witnesses, including himself. The respondent side also examined 2 witnesses, including herself. Heard amicus curiae of both the parties. Decision and reasons thereof. The issue number 1, the issue relates to cause of action for the suit. The petitioner filed a suit seeking decree for dissolution of marriage between him and the respondent, solemnized on 29/11/2009 as per Hindu rites and rituals. The respondent has denied the allegation leveled against her in the petition. The facts pleaded by the petitioner and denied by the respondent shows the existence of cause of action for institution of the suit by the petitioner. So the issue is decided in favor of the petitioner. Issue numbers 2 to 5. The issue numbers 2 to 5 are interrelated to each other. Therefore, the issue numbers 2 to 5 are taken up together for discussion. The petitioner's side relied upon 2 witnesses and the respondent side also relied upon 2 witnesses. Before proceeding further, I find it necessary to look through the evidence on record.
Where's the original evidence? Four witnesses.
4 witnesses from the petitioner side 2 and from the defendant side 2. And that evidence I have enclosed in the petition also, my lord.
Yes. Shall we go through this? You have copies of the evidence?
Yes, my lord. I have enclosed the in the petition also. In my appeal memo, my lord, that the evidence affidavit I have enclosed, my lord.
Okay.
The evidence of PW1 is at page 32, my lord. Huh? 32, my lord, the evidence of PW1. Because first two paragraph, your lordship may skip, my lord. From the 3rd paragraph, page 32, my lord, your lordship, go. That on 29 November 2009, I got married with the respondent Srimati Juma Das, and the said marriage was solemnized in Hindu rites and ceremonies in the house of the brother-in-law of respondent Sri Ratan Kumar Das at so and so. That since after our said marriage, the respondent came to my house and started conjugal life with me, and out of our said wedlock, one male child, namely Binayak Das, was born on 15/9/2010. That I am the only son of my widow mother, that is Sikha Das, alias Basanti Das, who is fully dependent upon me, as there is no one who can take care and look after my widow mother, and as such, was normally bound to keep my mother under my care and custody, and accordingly I have been maintaining my duty towards my mother. That since after our said marriage, my wife, that is respondent, treated me with cruelty both physically and mentally. After few months of our marriage, while I took my wife to my then place of service at Krishnanagar district, Nadia, West Bengal, along with my widow mother, I realized that my wife is a woman of extremely jealous nature. She used to doubt me in every time on talking with other women and even also with my mother. She used to pass remarks confidently saying that I must have had illegal physical relation with my mother. During our marriage life, it would appear to me from the behavior of my wife that she has been suffering from doubting others without any reasons. That's why she doubted noble sacred relationship of mother and son. She even never saw any courtesy, nodding to others, expressing herself disinterested with others. I always used to try to let her understand that we should keep at least courtesy relation with others, as in certain circumstances help of relatives, friends and colleagues are needed. But she never realized it and did not bother to avoid them, even causing insult to them. As a result, I was put in embarrassing position on many occasions. That during our said married life, on several occasions, my wife told me openly that she had an affair with a person prior to her marriage with me, and she was also interested to marry him, but she failed to do so due to her mother, elder sister and brother-in-law's objection. Sometime it appeared me that my wife was having some psychological problem. From her conduct, it appeared that she was no feeling for me. She always remained just like a stone doll, having no expression towards me. At the beginning of our married life, while my wife would behave with me in the aforesaid manner, I though shocked, but consoled myself, thinking that she might be changed in course of time. But the said behavior towards me by her increased day by day, and it was increased extremely after birth of our said child. She was so arrogant in her nature that she even used to refuse to take medicine while it was necessary. She was in the habit of taking all her decisions as correct and true, and throwing off my opinion and opinion of my mother, dishonoring extremely. That during my married life with her, I tried my utmost to satisfy her by providing everything she wanted. But her habit to remain upset always did not change at all. For her change of mind, I kept her at my service place many times after interval, at her wish and whim. She also allowed to stay her said brother-in-law's house sufficiently during the period of our married life, but her habit of dissatisfaction and displeasure remained as it was. That my wife gradually started to abuse myself using filthy language against me and my mother, and whenever I tried to let her understand that she, being my wife, should not behave in the aforesaid manner with me and my mother, but she would be violent against me and beat me with anything. On many occasions, my wife threw off all household articles towards me and my mother. She used to ill-treat me very badly without any cause or reason whatsoever. For last few years, my wife had been creating pressure upon me to free her from this marriage tie. That while I was posted at Masimpur, Silchar, Kasar, I urgently called the family members of my wife, that is her mother, elder sister and brother-in-law, and stated before them about my problems with her, but they did not try to solve the problem. Rather, they threatened me that if I go against her will and wish, then I will be faced the dire consequences. Even I will face various litigations. Thereafter, while my wife was in 8 months of pregnancy, wanted to reside in my rental house and assured me that she never behaved like that manner in future, as she understood her fault guilty. But she did not keep her promise so long, and even after 1 month, she began to behave as earlier. As a result, I was bound to separate my mother from my family. But surprisingly, there was no change in her thinking. After a few days, her sister and brother-in-law came to my said house and quarreled with me and threatened me as earlier and advised to my wife that if I do not obey her advice or direction, she must beat me without thinking its consequences, as because her brother-in-law is with her and he will remain in her favor. That in the month of January 2011, at the time of death of my uncle, my wife left my aforesaid house in that very date and started to stay at the house of her brother-in-law and returned to my house after 1 month after completion of all after that formalities, that is Shraddha. From that very date, my wife avoided physical relation, sexual intercourse with me by this or that plea. Even she did not allow me to touch her. And she used to talk with someone to mobile for unlimited time in my absence. And she used to leave my house often and return on late night or next day on plea to see her mother on inquiry made by me. It appeared false. That my wife did not take care of our child Binayak Das and I used to beat him habitually without any cause or reason. She did not provide food to our child timely. Our child was healthy at the time of his birth. On his earlier stage of childhood, he was normal, but due to negligence and ill treatment of my wife towards my child, he became abnormal gradually. That my wife always followed the direction of her brother-in-law. Several times she made written complaint against me before my higher authority on some false and baseless allegation with the help of her said brother-in-law. That my wife used to spend money at the instance of buying luxurious articles such as ornaments, clothes, furniture, dish TV, etc. unnecessarily. That since our marriage, the persistent and repeated negligence, ill behavior and dealings of my wife caused reasonable apprehension in my mind that it would be harmful and injurious for me to live and reside with her. The behavior of my wife caused and had been causing extreme mental distress and consequently detriment to my health. The harassment, mental torture, negligence, and cruelty as aforesaid practiced by my wife upon me made my life miserable, and it was impossible to live with a person of respondent's nature. The respondent failed to fulfill the minimum requirements of myself as wife, of our son as mother, and of my mother as daughter-in-law, homemaker, housewife. That I had not condoned myself in any manner. The cruelty practiced upon me, my mother, and our son by my wife, that is respondent, and with that regard, I was bound to file a suit against the respondent before this honorable court on 7 June 2013 under Section 10 of Hindu Marriage Act 1955 with a prayer for decree of judicial separation. And accordingly, your honorable court admitted my petition and registered the same as so and issued notice upon the respondent asking her to appear before this honorable court fixing date on 10/7/2013 for filing her written statement. After receiving notice, my wife left my family voluntarily and she has been residing separately till date. That my wife, after receiving the notice of death, should appear the honorable court on 10/7/2013 and in spite of filing WS filed one miscase by miscase number so seeking pendentalite maintenance and cost of litigation and thereafter filed written objection with false and baseless allegation. She also lodged an FIR at Karimganj police station against me under section 498A IPC with false and hot allegations. That in FC number so I along with my mother submitted our examination in chief affidavit as PW 1 and 2, but due to non-availability of my leave from my service, I could not attend along with my mother, that is PW 2, before the court on date so fixed for cross-examination, and as such, your honorable court closed the cross-examination of PWs on 23/3/2015 and date fixed for evidence of DW 1 on 19/5/2015, and subsequently the honorable court on 11/3/2016 by an order dismissed that suit on the basis of withdrawal petition filed by me. That the cruelty as aforesaid practiced by the respondent wife upon me and desertion of more than 2 years. 2 years means in the year 2016 petition was filed. That time 2 years. between the parties are the another cause of action for filing this suit which arises within the jurisdiction of the Honorable Court. My lord, then the PW2 at page 37, her mother corroborated the evidence of his son, my lord. So basic case is that, my lord, my basic grievance is that there are allegations from both the sides. And now, my lord, in the mediation that took place in the before this honorable court, my lord, she has clearly stated that I will not live with you and I will not give divorce, my lord. So that question your lordship has to decide, my lord. If they are not staying together since the year 2013, my lord. Since the year 2013, they are not staying, my lord. They are staying separately, my lord. So what is the point of so better to get a divorce decree, my lord. And the learned family court, my lord, while determining the case, my lord, relied on the statement of the DW only. They did not rely on the statement of the PW, my lord. My lord, in para 58, while dealing with the issue numbers 2 to 5, so page number 58, my lord.
Yes.
So while dealing with the issue numbers 2 to 4 from in the paragraph 8 below, my lord, the bottom side, paragraph 8, that is the deposition of PW1, my lord. The discussion regarding the deposition of the PW1, my lord. And then, as I have already read out before your lordship, then paragraph 61, my lord, paragraph 9. PW2, Srimati Sikharani Das alias Basanti Das, mother of the petitioner, during course of her evidence has fully corroborated the evidence of the PW1 on material particulars. Nothing has been elicited from cross-examination of the PW1 and PW2. Now, my lord, what DW1 has deposed, my lord, that starts at paragraph 11, my lord. The respondent as DW1 has stated that she was married with the petitioner socially, and after marriage, the petitioner started demanding a wall TV from her mother as dowry, but her mother could not fulfill his demand, for which he started torturing her. The respondent as DW has also stated that after about 15 days of the marriage, the petitioner took her and his mother to his place of posting in West Bengal. And at that time, she became pregnant. But the petitioner and his mother used to abuse her in slang language for not giving furniture at the time of marriage. And her mother-in-law used to keep her under lock and key as per instruction of the petitioner during his office hours. The respondent as DW1 has further stated that in March 2010, her mother-in-law brought her to the house of her sister at Silsor and left her there, and in such situation, she tried to contact the petitioner over phone, but he cut off the line, and hence she contacted the petitioner through his office for taking her, and then he replied that he would take her after his transfer to Masimpur. But he did not take her after he was transferred to Masimpur, for which she went to his residential house at Masimpur and started living there, and thereafter the petitioner told her that he had to go to training, and at her advanced stage of pregnancy, it was not possible for his mother to take care of her. And then he took her to her sister's house and left her there. The respondent as DW1 has also stated that on 15/9/2010, she gave birth a male child, and entire expenditure of the delivery of the child was borne by her sister and brother-in-law. And after delivery, on her pressure, the petitioner took her to his residential accommodation along with the baby, but the petitioner and his mother started torturing her and the baby, and even they did not provide proper food to her and to her baby. Rather, they compelled her to sleep on the floor with the baby on the plea that her mother did not give furniture at the time of marriage, for which she encased her fixed deposit, which was invested by her prior to the marriage. and purchased an alna, one sofa set, one steel almirah, one dressing table, one washing machine, and a showcase to satisfy the petitioner and his mother. But the petitioner started to sleep separately on the plea that his sleep would be disturbed due to cry of the baby. And when the baby fell ill, she had to take money from her mother for treatment of the baby. But the petitioner did not provide any help for medical treatment. The respondent at DW1 has further stated that thereafter the petitioner was transferred to Karimganj and they started to live in a rented house, and during Kali Puja, the petitioner took leave to visit his maternal uncle's house with his mother, and she was left at Ramnagar, Silchar with her baby to live in her sister's house at Silchar. And since that, he cut off all relation with her, for which after waiting a month, she came to Karimganj with her baby, but found the house was under lock and key, and at that time, her baby was suffering from fever. And then with the help of persons from his office, she entered the house by breaking open lock and key, and thereafter she repeatedly requested the petitioner to bring medicine for the baby, but he did not pay any heed to it. For which, finding no other alternative, she brought some homeopathic medicine for the baby. And after a few days, taking leave from his office, came and told her that he would divorce her and would marry again, and then he and his mother left his residence, leaving her and her son in uncared condition. The respondent as DW1 has also stated that the petitioner filed a suit for judicial separation against her in this court, which was subsequently withdrawn by him. And at that time, she was residing in his residence at Karimganj, and thereafter he filed this suit. While she was residing with him till March 2016, condoning all his misdeed towards her, taking it as a common matter, and hence she did not want to get divorced and want to spend her entire life with petitioner as his wife with their handicapped son, and as such the instant suit is liable to be dismissed with cause. The respondent in her cross-examination has stated that when she was in West Bengal, her mother-in-law used to go out of the house and lock her up, saying that as it was a new place, it was not safe, and she did not go out of the house, and after returning, her mother-in-law used to open the lock, and she did not complain about this as it was a normal happening. She further stated that the petitioner and his mother never used any slang language during quarrels, and behavior of the petitioner towards the son was normal like father and son, and her mother-in-law used to make the purchase for her and her child. My lord, this part is important. In cross-examination, she has admitted that she further stated that the petitioner and his mother never used any slang language during quarrels. She has admitted in the cross, my lord. And behavior of the quarrels and behavior of the petitioner towards the son was normal, like father and son. And her mother-in-law used to make the purchase for her and her child. So it is in the cross-examination, she has admitted it, my lord, that they have not, her husband and mother-in-law have not used any slang words towards her, my lord. DW2 Srimati Soma Das, elder sister of respondent, during course of her evidence has corroborated the evidence of the DW1 on material particulars. During her cross-examination, she has stated that she heard from the respondent about the mental torture on her. She heard from the DW. In the instead case, it is found that on 29/11/2009, the respondent was married to the petitioner, and after marriage, one male child was born out of their wedlock, who is about 10 years old and suffering from arthritic disease, and staying with the respondent. And since 14/7/2013, both the parties have been living separately from each other without resumption of their marital relation. The present case has been filed by the petitioner on the ground of desertion and cruelty. The petitioner time and again stated that the respondent, because of her ill temperament and desperate nature, could not adjust with him and his mother. But the petitioner, as PW1, stated that his mother never told him what had happened when he was in the office, and he was a witness to whatever happened when he was present in the house. So it is clear that the respondent did not misbehave with the mother of the petitioner. According to the respondent, her mother-in-law used to make purses for her and her son. The PW2 admitted in her cross-examination that she always traveled with her son and daughter-in-law to different places to which her son was transferred. From this admission of the PW2, it is clear that if PW2, that is mother of the petitioner, would have any problem with the act of respondent, the PW2 would not travel with her son and daughter-in-law to different places to which the petitioner was transferred, and also would not make purchase of for the respondent and her son. My lord, this finding cannot be taken up because, my lord, the mother of the petitioner, she was a widow. She is alone. So whatever be the behavior of her daughter-in-law, she has to go with her son. But from that, my lord, this assumption cannot be drawn, my lord. That because she had a cordial relationship with her daughter-in-law, that's why she is traveling with her son. Because she is alone, the son has to take her with him because she is a old widow, my lord. So this assumption, my lord, cannot be drawn up, my lord. The DW2 during course of her evidence stated that the respondent lived and resided with her husband, condoning all his misdeeds against her, taking it as a common approach of a husband towards his wife. And the respondent did not want divorce and want to spend her entire life with the petitioner as his wife with their handicapped son. The DW2 supported the evidence of the DW1 and stated that though the petitioner used to send the respondent in her residence to avoid his responsibility towards her, but she used to go back to his house within a short gap in spite of mental torture on her in various forms committed by the petitioner and his mother, and that the respondent does not want divorce and wants to continue married life with him, and as their only son being autistic, needs presence and cooperation of his father, that is the petitioner, for his treatment and upbringing. The petitioner as PW1 admitted that in the year 2013, he got transferred to Gujarat, and in the same year, he filed a case for judicial separation. And at the time of filing of the said case, the respondent was staying in his house, and that during the pendency of the case for judicial separation, the respondent started residing at Karimganj in a rented house along with her son, and that the petitioner nowhere stated that the respondent left and deserted him permanently, terminating the existing state of cohabitation with him and putting an end of her married life with him, which is seeks the very root of the plea of the desertion by him. And this finding is also, my lord, not acceptable because, my lord, because from the evidence of the PW1, my lord, it clear that after receiving the notice of the judicial separation in the 2013, my lord, she has left the house, my lord. And since then, she has been living separately. So now a contrary view has been taken by the learned trial court, my lord. It is thus clear that no tangible material has been placed on record to point out any blame on the conduct of the wife, which may justify apprehension in the mind of the husband, and that it will not be possible for him to continue to live with her. He was taken a firm stand that he wants to live with his mother and not to live with the wife and son at all. On the other hand, the stand of the wife is that she is willing to adjust and live at any place with the husband. An educated woman cannot be expected to accept every arbitrary unilateral decision of the husband. There has to be a mutual adjustment and appreciation of difficulties of each other. It is not a case where the wife has not maintained the matrimonial relations. If she is living separately, it is not for any extraneous consideration on her point. In these circumstances, the ground of cruelty cannot be accepted on mere asking of the petitioner. The parties have one son who is suffering from arthritis disease, and there is no reason for granting a decree for divorce. In Chetan Das versus Kamla Devi reported in AIR so it was observed, matrimonial matters are matters of delicate human and emotional relationship. It demands mutual trust, regard, respect, love, and affection without any sufficient play for reasonable adjustments with the spouse. The relationship has to conform to the social norms as well. The matrimonial conduct has now come to be governed by statute framed keeping in view such norms and change social order. It is sought to be controlled in the interest of the individuals as well as in broader perspective for regulating matrimonial norms for making of a well-knit, healthy, and not a disturbed and prosperous society. Institution of marriage occupies an important place and role to play in the society in general. Therefore, it would not be appropriate to apply any submission of irretrievable broken marriage as a straitjacket formula for grant of relief of divorce. This aspect has to be considered in the background of the other facts and circumstances of the case. Institution of marriage occupies important place in the society. Concept of divorce was unknown under the Hindu law and has been introduced only by a statute. Policy of law is not to dissolve a marriage unless a case is made out. Responsibility to continue the marriage is not only the wife, but also of the husband. In the present case, conduct of the wife has not been shown in any manner to be of such objectionable magnitude as to amount to cruelty. My lord, so paragraph 18 by holding this, they have totally disrelied on the deposition of the PW1 and PW2. Totally they were disbelieved because the PW1 and PW2, there is no reliance in their deposition, my lord. During the course of trial, several attempts were made for reconciliation, but the petitioner was not willing to take the respondent back. On the other hand, the respondent was not agreeable to divorce. From the above discussion, it is found that the respondent has enough ground to live separately. Hence, there has been no desertion on the part of the respondent. Accordingly, the petitioner also failed to establish the ground for desertion. In view of the reasons discussed above and the findings arrived, I hold that the petitioner is not entitled for a decree of divorce as prayed for, and also no other relief is required to be granted in this case that the issues are decided against the petitioner. In the result, the suit filed the petitioner against his wife, that is respondent, is dismissed on contest. So, my lord, in paragraph 20, it has been held that it is found that the respondent has enough ground to live separately. Hence, there has been no desertion on the part of the respondent. It is also contradictory view. She has enough ground to live separately. If she is living separately, leaving the petitioner, my lord, so that is desertion, my lord. Already the cruelty part and desertion part has been by way of evidence, my lord, PW1 and PW2 has stated. But while coming to a conclusion, my lord, that part, my lord, the reliance has not been given on the deposition of the PWs, my lord. And one important thing, my lord, there is a petition was filed, my lord. In the meantime, my lord, a petition was filed under section 65B of the Indian Evidence Act to adduce evidence regarding the cruelty, one compact disc, my lord, the recording, voice recording of her wife, of his wife. That petition was filed before the learned trial court. The petition was numbered also, ticket was also cut, but thereafter also it was not taken up, my lord. Your lordship may, the original copy of the petition is, your lordship may peruse, my lord. Petition was numbered, my lord, because by this evidence, the petition appellant wants to depose something, my lord, regarding the cruelty, the recorded version, my lord. But even after, my lord, numbering the petition, it was not taken up for consideration, my lord. If, my lord, this petition, My lord, so my humble submission is that, my lord, if there are so many differences, since 2013, they have been staying separately, my lord. So what, and in fact, it is a admitted position, my lord, in the mediation process before this honorable court. She came and she has straightly said that I will not stay with you and I will not give divorce, my lord. So what is the point, my lord? So my humble prayer that, my lord, since they have admittedly since 2013, they are staying separately.
My lord, in this case, I have filed my affidavit, my lord.
Okay, I'll just ask you a question. Are you willing to come back?
My lord, what happened, the respondent was suffering mentally and physically, my lord. And because of that, because of physical torture, she gave birth to a, my lord, abnormal child, my lord. So because of that, my lord, she is not willing to live with him in the same house, but she does not want to take divorce. She
Why?
wants to live in a separate house with her son, my lord. Not with her mother-in-law, my lord. That is the thing. She does not want divorce, but she wants to live in a separate house. She does not want to, does not want divorce, my lord, because the child needs father as well as mother, my lord. Because it will affect her son also, who is otherwise also abnormal, my lord.
But regarding the son, my lord, it is in cross, she has stated that his behavior with son is normal like father and son. In cross,
No,
she has stated.
that is there, my lord, but because of the, my lord, interference of his mother-in-law, my lord, of her mother-in-law, there is lots of problems propped up. Your lordship has already heard, my lord.
That is the normal
So-
problem of the society, my lord. Because she wants to live with her husband only, not with the
Not with
mother-in-law.
her husband, with her son. And husband will
Supposing
take
mother-in-law
care of
goes-
her as well as son, and he may live with his mother, but take care of her and her son. my lord.
Supposing your mother-in-law goes, are you willing to come back?
But that is not proper, my lord. Let
No,
him
no, it
live
is
with
not,
her.
it is
with his
maybe
mother.
proper, not proper. I'm asking you a question.
Yes, my lord.
Are you willing to come back?
Yes, my lord.
You'll come back. You'll come back to your husband.
Yes, my lord.
So her intention is clear, my lord. A son, my lord, he cannot, my lord, fulfill his duty of his old ailing widowed mother, my lord, because of her. So it is admitted now, my lord. How that can be, for a society, my lord, it is a very bad message. A old ailing widow lady, my lord, the
That is why
son
she
cannot
does not want to
fulfill,
separate
the son cannot
her husband
do
from his
his
mother,
duty,
my
my lord. Normal duty to take care of his mother.
Yes, my lord, her husband may take care of his mother, he may live with her also, but he will take care of the respondent as well as his son, my lord. She will live in a separate house, that is there, my lord, but she does not want divorce.
Where are you living now?
And now she is living in Guwahati.
In a rented house?
No, my lord, now in her sister's house, my lord.
Her sister house in Silchar.
Only sisters here.
Sister's house, my lord. Earlier, she used to live in Guwahati, maybe transferred by job, but she is living with her sister, my lord.
Sisters in Silchar.
My lord, last year, my lord, she was living here in Guwahati.
Your intention now is becoming clear.
Yeah. And that is a bad message to the society, my lord.
But for torturing your, my lord, daughter-in-law, that is also a bad message, my lord. His mother used to, mother and son, both of them used to earlier, they used to torture her. Only because of dowry, my lord, her mother-in-law used to torture her. He did not even allow her to sleep on the bed also. But just because she did not bring furniture with her.
When he filed the separation suit,
Yes, my lord.
you, on your own volition, you left the house.
No, my lord.
Yes.
At that time, she was living with him, my lord.
No,
He was living with him,
Yes, my lord.
and when he filed his
after
separation.
receiving the notice of
After
the,
receiving notice, he left, so he had to withdraw.
Yes, my lord, he had withdrawn. Yes.
yes,
So you lived on your own.
My lord, she used to come back very frequently, and because of the torture, again she used to go.
no,
But she
no.
did not desert her, my lord. She did not desert her.
After 2013,
There is
no,
no
my lord.
question of desertion.
Before filing of that suit, my lord, there were several times of coming, going, my lord.
Where are you posted now?
Now he is posted outside Assam, my lord. Outside Assam. Present place of posting.
Do you have any idea where you're posted now?
Yes, my lord. I will get the information right now, my lord.
The whole idea is we want to meet them.
Yes, my lord. I understand, my lord. Yes.
Yes, my lord, that will be better, my lord.
You have put it? He is now posted at Delhi, my lord, in a armed force, my lord, discipline force, my lord.
Can you come down?
My lord, if your lordship wishes, my lord, as per your lordship's order, he has to come down, my lord. Because I understand, my lord, if your lordship, both the parties, my lord, appear before your lordship, my lord. And a date may be fixed, my lord. Then if your lordship wants to have them, my lord, he has to come down, my lord. Yeah. I said he's working at SSB, Sashastra Seema Bal, now posted at Delhi, my lord.
Because you'll have to take leave and all, no?
Yes, my lord.
So how long will it require? We are thinking of that. For his welfare also, we are thinking. She's in Guwahati only.
She's Silchar also, she can come any moment.
No, just check up if she's in Guwahati or Silchar.
Yes, my lord. Your lordship may give me 10 minutes, I'll make a phone call.
I will gather the information, how long he will take, my lord, because if by showing your lordship's order, then leave will be granted, my lord.
You also check up.
My lord, she is staying in Guwahati, my lord, in a rented house with her son. And her son is studying in a school also.
She's working,
Yes,
respondent is working.
yes. Respondent is not working. Respondent is living with her son, with baby, my lord, and the baby is going to school. She is living in a rented house. My lord.
Who's paying the rent, ma'am?
My lord, she is getting maintenance
From the.
from the
Yes.
husband. He is paying maintenance regularly.
How much?
Maintenance 7,000.
Monthly $7.
So your lordship may fix up a date so that both of them.
Yeah, Bora, how long you take?
My lord, I think if your lordship fix in the last part of June, because he's saying that he will take 1.5 month, my lord. So last part of June, my lord, if your lordship fixes.
Heard Mr. DB Bora. Also heard him as SP.
SB.
Hearing the letter. Way of the office. That's what the applicant will respond to the paper. This the matter on. June last week, with difficult.
Summer vacation was.
26 June.
26 or 28, my lord.
28 will be very tight.
26. Because it is convenient for her if she is
Yes,
staying here.
correct.
So, or else immediately on reopening, my lord. Because he is saying that, my lord, he will take, he is in BSF, my lord. So he will take at least one or 1.5 month, my lord.
19th of July.
Yes, my lord.
On which date? Both the applicant.
Deeply obliged, my lord.
You can take back this one.
Yes,
You
sir.
want to keep it on record or you want to take it back?
My lord, the photocopy is annexed with the petition, my lord. The original copy I can keep. My photocopy is annexed with the petition. Obliged, my lord. কোনটো petition? হ্যাঁ, হ্যাঁ, কি বুলি নাই নাই সেইটো কেছ হা নাই নাই বুজি পাইছো সেইটো কেছত